Be cool, be kind, be classy. The cupcakes so sweet and sexy. Have fun and enjoy the journey. Just have a good attorney. No big whoop, no biggie. She lives near New York City. And not just a YouTube show. When you know, you better grab a straw. Learn about the law. It's cool here in the shade. Sipping motions of lemonade. Cool heads will prevail, kindness will never fail. Be classy and vastly wise. Oh, Melanie Little is going live. Oh no, where is Melanie? Follow the island's melody. Is a concert within reach. No surprise, she's at Jones Beach. She heard some music far away. Captain Jack Sack Harbor Bay. He sings and his piano plays. Not all sounds are waterways. Speaking Yiddish or Latin, it's not just for Manhattan. It's for Pilta and Michigas. Ridiculousness that insanus. Oy vey, Marcus. Proset, that's for schmucks. Be cool, be kind, be classy. My cupcakes sweet and sassy. And not just a YouTube show. When you know. Cool heads will prevail. Kindness will never fail. Be classy and vastly wise. Melanie Little is going live.
Here I am. Good morning. Good afternoon. Depending on your part of the world. Good morning, good evening, good afternoon, good night. How's everybody doing today? Today is Thursday, July 9th, 2026. And the Karen Reed anti-slap motion to dismiss has finally hit the docket in the case of Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert versus Karen Reed and Aidan Kearney. Aidan's case, Aidan's motion has not yet hit the docket. I don't have it yet, but I will save that for a separate show because it's going to be a lot of reading today. So if you hate the sound of my voice, today might not be the day for you because there's a lot of reading. The weird thing is, just as sometimes happens over there in Norfolk County or in the e-filing system of the Massachusetts courts, when you pull up the motion, it's like 900 and something pages, but it's not really. It's just 30 pages and it's been repeated however many times and it's over 900 pages. And then the opposition of the Haas plaintiffs is like over 1,000 pages. It's not really. It's not really. It's just a million copies of it. I don't know why it does that, but it does it. It does it. I don't know if anybody else has covered this yet on the Tubes of You because I've been running around all morning. And it's, it is what it is. Today's going to be a nice ASMR reading stream. Again, if you prefer to read the papers on your own and you don't like the sound of my voice, rather than publish that all over the internet, why don't you just leave and go do it yourself? It's amazing to me the things that people spend their time doing all day long on the internet is wild. I mean, do they really have no lives? I don't know. It's insane. But anyway, here's a great quote of the day. We have two of them today. So this is the first one. Check this one out. Adam Smith was an 18th century Scottish moral philosopher and pioneer of political economy, widely regarded as the father of modern economics. This is Adam Smith. Well, yeah, 1700s. This is the right Adam Smith, right? Adam Smith said, and I think this is so perfect for today. Thank you to Anonymous who sent it to me. Showing mercy to the guilty can become cruelty to the innocent because justice loses its balance when wrongdoing goes unpunished. Huh? How about that? Adam Smith. Showing mercy to the guilty can become cruelty to the innocent because justice loses its balance when wrongdoing goes unpunished. That would be a great thing for Judge Gilday to pull out one day. We know he loves to quote from sources, sometimes cited, sometimes anonymous, but it is on point, don't you think? I think so. All right, today's motivational quote of the day from the Daily Motivational Calendar is J.R.R. Tolkien. who said, all that is back to one, J.R.R. Tolkien. All that is gold does not glitter. Not all those who wander are lost. The old that is strong does not wither. Deep roots are not reached by the frost. Oh, if any of you were feeling old today, this is a good one. All that is gold does not glitter. Not all those who wander are lost. The old that is strong does not wither. Deep roots are not reached by the frost. Oh, I really like that. I really like that one. That's it. That's our quote for Thursday, July 6th, 2026. And of course, we also need an affirmation for a badass. This is a good thing to do while we wait for people to come in, because I only scheduled this about, I don't know, 45 minutes ago. I don't know if anybody got a notification or not. Let's dig into our affirmation for a badass, because you're all badasses, every single one of yous. All right. I've heard that quote before, but it's usually broken down to just not all who wander are lost. That's the one that I knew. And here we go. I am a little tongue-tied today, which is not a good sign for reading lots of documents, but let's go. Your affirmation of the day. I am brave. I am fierce. I can do hard effing things. You can too. I am brave. I am fierce. I can do hard effing things. There it is. If you needed to hear that today. If you needed to hear that today.
You're welcome.
Afferman says you're welcome. You're welcome. How's everybody doing today? Good? Good. For 3 days, I have been working on a presentation for you on the 16 children that were found in squalor in Ohio for 3 days. And every day something pops off, and I've been sidetracked, but we're here for this. We got to do it today. But I have so much to tell you about that horrific story in Ohio. And it shakes me to the core. I don't know what to make of it. And I'm shooketh. If anybody else is following that story, let me know. Let me know if you want me to catch you up all in one episode of all the things that I have learned. Oh, Mike, 16 children were found in an Ohio, I don't even know what to call it, in a 12 by 12 room in an Ohio teardown, let's just say. Ages 18 months to 18 years, living with the grandparents and the alleged parents. The mother of all 16 children got pregnant for the first time at 13. And apparently she hasn't not been pregnant since, and they were living in squalor. And the neighbors had no idea there were any children living in the house at all. They had lived there for a couple of years. The mother and the father, let's just say, got married at 15 in West Virginia. The grandparents lived there also. It's a horrific story. All four have been charged, the grandparents and the parents, with 16 counts of child neglect and endangerment. All of the children were in horrific condition. I don't even know if any of them are out of the hospital yet. It is horrific. I don't know if the mom is pregnant again. I don't know anything like that, but I will catch you up. That will be a story for a different day, because I have to be in the right mind space to do that. And so do you. The mother, victim number one, 100%. I agree. Did you watch her arraignment? She's dead behind the eyes. It's something I don't know. I don't know what to make of it, but I am shooketh. They found them because the father, who's like 36, I think the mother's like 33, had a warrant for indecent exposure, or 4 episodes of indecent exposure, and they went to pick them up, and that's how they found these children. The motion is not 900 pages. It is 30 pages repeated however many times it takes to get to whatever it was, 991. So don't worry about it. Yeah, the grandfather was released. I know all the details, but it is a trigger warning. And so we're going to do it on another day. I just wanted to bring your attention to it. It sounds like a Law and Order SVU episode. It really does. It really, really does. Kiss your children. All right. And let's get back on topic. We are going to the defamation case today of Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins against Karen Reed and Aidan Kearney. Let me take Adam Smith down and put the motion papers up. And here we go. Please remember the rules. The rules are very simple. In the chat, be nice or leave. It's very, very easy. Be nice or leave. No self-promotion, no directing to other channels. Please don't use any words that YouTube doesn't like because they've got AI scanning the chat. And I'll be damned if I'm going to have my channel stricken because somebody can't control their tongue or their typing. Okay. All right, let's go. This is defending Karen Reed's special motion to dismiss pursuant to the anti-SLAPP law, General Law 231. We know what that is. So that I do not read every single page of this. There may be some portions I skip over and I just say citation, citation, citation. That will stand for the case law. I will scroll through it slowly so that if you would like to, you can go back, screenshot it, and go look up the cases later for yourself. A lot of you like to really get deep into this. Look at Angel the Aussie. She really is an angel because she came in here and gifted 10 memberships. And who's better than Angel? Welcome to all the 10 members who were so graciously gifted by Angel the Aussie. That's really sweet of you. Thank you so much. Oh, look who's here. Las Vegas cops are here. What? No, I expect you to police the chat. I'm not threatening you. You could police the chat for me if you like. That's the kind of protection I need lately based on everything that's going on behind the scenes that I don't really talk about. I talked about it a little bit one day, but it is better that I keep quiet and just let the things happen behind the scenes that are happening. Thank you, Las Vegas Cops TV. Miss you guys. Love you guys. And Scott didn't get to boot anyone yesterday? Wow. You mean, there were a couple of those $2 super chats from you-know-who. And look at Susan gifting 5 memberships. She's awesome. And please smash the like button on your way in. And if you are watching on the replay, please remember to hit the like button on the replay as well. Okay, thank you. Oh, Brian Goodman, Mr. Goodman is here. He's like, I'm sorry I cheated on you last night. He was watching the Glare apparently instead of me. And now he's about, all right, apology accepted. I'll allow it. D threw him under the bus. That's hilarious. Thanks, Goodmans. All right, let's get into it because it's going to be a long day. So put in your earbuds. If you're at work, please don't let me distract you from your progress at work. Shout out to the nurses. I don't know if they're back at work today. I did see a headline this morning at Brigham Women and Children's Hospital. Is that the proper name? The nurses were on strike yesterday for one day, and then they went back to work today, and they weren't allowed in the building. So I don't know what's happened. But I just want all the nurses to know. I know you watch me. I know you're here, and I support you, and I stand with all the nurses because you are angels on earth. Brigham and Women's Hospital. Thank you. Down the rabbit hole we go. My sister is a nurse there. Your sister is an angel, and we stand with the nurses. Nurses are the most important part of your hospital stay because the doctors get all the credit and the nurses do all the work, and the compassion and the care that you receive from your nurses makes a good or bad hospital stay. And that's it. Okay. We love the nurses. All right, let's go. Introduction. Karen Reed was charged and then prosecuted twice for the death of Boston police officer John O'Keefe III. The first criminal trial ended in a mistrial on July 1st of 2024. The second trial, which commenced in April of 2025, resulted in an acquittal. Her defense at trial was consistent, clear, and was supported by overwhelming circumstantial, medical, and scientific evidence. She did not kill Mr. O'Keefe and was framed by the conflicted and corrupt police investigators and the individuals in the house at 34 Fairview who were involved with Mr. O'Keefe's death. Oh, that's how you come out swinging in your introductory paragraph. Ohio, the case in Ohio is Vinton County, I believe, Vinton County. Plaintiffs have now sued Ms. Reed for speech pertaining to her defense. The legislature, however, has enacted very broad protection for petitioning activities, like Ms. Reed's. The anti-SLAPP statute provides civil immunity for the exercise of the right to petition the government. Its protection extends not only to statements made directly to government bodies, but those made in connection with ongoing judicial proceedings and statements reasonably likely to enlist public participation. The statute immunizes this broad category of conduct from suit, except where it is, quote, devoid of any reasonable factual support or any arguable basis in law. Citations. Here, and as explained below, the anti-SLAPP statute requires dismissal of all plaintiffs' claims against Ms. Reed because they are based solely on her petitioning activity, and plaintiffs cannot prove by a preponderance of the evidence that her petitioning was devoid of any reasonable factual support or arguable basis in law. Accordingly, Ms. Reed moves to dismiss the claims against her under the anti-SLAPP statute and pursuant to Massachusetts Rule 12b-6. Ms. Reed also seeks her attorney's fees pursuant to the statute. And that is part of the statute that if you succeed, you are entitled to your attorney's fees because anti-SLAPP statutes are designed to prevent frivolous litigation and specifically designed to prevent citizens being prosecuted for the things they say. That is protected speech. Civilly. In support of her motion, Ms. Reed submits the affidavit of Karen Reed. We're going to see an affidavit from Karen Reed today. The affidavit of Damon Seligson, including exhibits appended thereto. Factual background. Unlike a motion to dismiss for failure to state a claim under Rule 12b-6, a court faced with an anti-SLAPP motion shall consider supporting and opposing affidavits stating the facts upon which the liability or defense is based. Here, Ms. Reed sets forth the following facts drawn from the allegations in plaintiff's amended complaint and the affidavits and exhibits filed herewith. So just to explain that to you, take the legalese out of it for a second. An ordinary motion to dismiss on the papers alone that does not involve petitioning activity, you're not allowed to include additional evidence like affidavits from the parties or anyone else. But in an anti-SLAPP motion, the judge can. Thank you for all your compliments in the chat. I love you guys so much. You're so sweet to each other. At count one of their complaint, plaintiffs allege that Ms. Reed repeatedly published false statements asserting or reasonably understood as asserting that the plaintiffs were responsible for the murder of Mr. O'Keefe and a cover-up of their purported role in that murder. Citing complaint paragraph 147. Plaintiffs do not identify the allegedly defamatory statements in count one, but the complaint only identifies a handful of allegedly false statements by Ms. Reed about the plaintiffs. And these are all bullet points. Stating to investigating officers prior to her arraignment that Brian and Colin Albert beat up Mr. O'Keefe, which statement was released to the public during a judicial hearing in April of 2024. And all these things are cited with paragraphs so that the judge can easily find them in the attached exhibits. Stating in a discovery motion during her first prosecution that Brian and Colin Albert were responsible for Mr. O'Keefe's death and that Ms. McCabe was the mastermind who covered it up. Forwarding the motion to defendant Aidan Kearney, who then published it. Telling Mr. Kearney through an intermediary that Brian, Nicole, Chris, and Julie Albert all testified to a grand jury that Colin Albert was present at the Alberts' home at 34 Fairview. Telling reporters during her second trial that Ms. McCabe's testimony at the trial was perjured and that she was lying. Telling a podcast on January 12th, 2026, that Mr. O'Keefe entered the Alberts' house, quote, and much sooner than later met his demise, end quote, and that, quote, someone in that house killed John O'Keefe, end quote. Remind me, was the January 12th, 2026 podcast Rotten Mango? I think it was. As described below, all these statements constitute petitioning activity. Similarly, at counts 3, 4, 6, 7, 9, and 10, plaintiffs assert various non-defamation claims against Ms. Reed. Specifically, counts 3, 6, and 9 allege that Ms. Reed is liable for aiding and abetting 3 discrete torts allegedly committed by Mr. Kearney: defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. They all allege the same activity, that Ms. Reed, quote, continuously and intentionally provided defendant Mr. Kearney with non-public and or confidential information about her criminal case. Counts 5 and 9 allege intentional and negligent infliction of emotional distress based on Ms. Reed's alleged campaign of false and outrageous statements about plaintiffs. See also the negligent infliction of emotional distress count based on Reed's campaign of outrageous, cruel, and malicious lies. The emotional distress claims appear to be based on the same statements and conduct underlying the direct defamation count and the aiding and abetting counts. Plaintiff's final claim against Ms. Reed, count 13, alleges a civil conspiracy between Ms. Reed and Mr. Kearney, quote, an agreement to defame the plaintiffs and to inflict severe emotional distress on them. I'm breaking from this for a second to just remind you that yesterday, when we were talking about the judge's conduct and the tweet of Aidan Kearney that was apparently sent by Michael Proctor's attorney to the judge, which prompted the judge to infer, based on a UTC timestamp and not an Eastern Daylight Time or whatever time we're in right now, Eastern timestamp, it led the judge to infer that Aidan Kearney leaked private information from Michael Proctor's affidavits that were filed on June 8th, 2026 at 2:22 p.m. because whoever sent that tweet to Proctor's attorney sent it not in its proper East Coast time, but in its UTC time. And therefore, it read 2:52 p.m., which would have been 30 minutes after those impounded materials and affidavits from whatever provider the judge didn't think was qualified enough to sign off on Michael Proctor not being able to come to his deposition. And that prompted something like 3 weeks later, because Proctor's attorney didn't send that tweet to the court until I think it was June 25th, prompted the judge to call in every single lawyer, have 32 people sign affidavits that they didn't leak it and they didn't know who did, and then started threatening some ethical violations and some horrific potential sanctions like dismissal or default if it happens again. I think there's a big problem here with this judge handling any case that has to do with Aidan Kearney, because he has told a worldwide audience that he believed it. And by making all of the attorneys swear that they didn't leak it, do you think that maybe he made the inference or was told, oh, it looks like Karen Reed is leaking private documents to Aidan Kearney again, and releasing them to the public? I think it shows bias against Aidan Kearney. I don't think that he should be handling any cases that have to do with Aidan Kearney, because we know the world is watching. I have a worldwide audience. If you're here from outside the United States, please tell us where you're watching from so that everyone else knows where you're watching from. My opinion is it's a problem because now the world knows it. And he has said several backhanded things to Karen Reed's attorneys. Not in this case, though. Remember, that's the other case. But again, Judge Gilday is assigned to both cases, right? So he's very familiar with this defamation case too. And by, having that worldwide spectacle of a conference, which was a soliloquy, spanking all the attorneys, I think if you read between the lines, there are some things that perhaps the judge is considering that he shouldn't be considering because it's a different case involving the same person that he says tweeted the private information. It's a problem, in my opinion. For the reasons set forth below, these counts should be dismissed pursuant to the anti-SLAPP statute because they are based on the same statements that underlie count 1, all of which fall under broad definition of petitioning activity in the anti-SLAPP statute. Oh, and I'm also going to point out, for those of you who weren't here or don't know, that Aidan Kearney had the information that Michael Proctor was possibly in mental health treatment in Florida 2 days before those sealed affidavits were filed, because he talked about them on his live show, and we went into it in great detail last night. We went through the whole timeline. And so he did not leak any private information, and that was a red herring. Argument 1, the Massachusetts anti-SLAPP statute authorizes a defendant to file a special motion to dismiss when facing claims based on the defendant's exercise of her right of petition. The statute's powerful procedural protections aim to foster the speedy dismissal of claims based on petitioning unless it was devoid of any reasonable factual support or any arguable basis in law. The SJC has adopted a 2-stage inquiry when evaluating a special motion to dismiss. Under the first stage, the movant, which in this case is Karen Reed. Karen Reed is moving to dismiss. Under the first stage, the movant must make a threshold showing through pleadings and affidavits that the claims against her are based on the movant's petitioning activities alone and have no substantial basis other than or in addition to the petitioning activities. If the movant carries its threshold burden, the second stage of the analysis requires dismissal unless the non-movant, meaning Brian Albert, Brian Higgins, Jen McCabe, and Colin Albert, can prove a negative, that the movant's petitioning activity, 1, was devoid of any reasonable factual support or any arguable basis in law, and 2, caused actual injury to the non-movant. So it's both things. You have to be able to prove both things. That everything that Karen Reed said had no reasonable factual support or any arguable basis in the law, and it caused you injury. The non-movement's second stage burden is a difficult task. The non-movement, which in this case is the Haas plaintiffs, must establish the lack of any reasonable factual support for the petitioning activity by a preponderance of the evidence. Furthermore, in the case of conflicting affidavit testimony, the reviewing court cannot resolve disputed credibility issues in favor of the non-movement. Thus, the evidentiary support in favor of the special motion proponent's petitioning activity must be quite limited to satisfy the non-movement's burden and avoid dismissal. Further, the anti-SLAPP statute provides that if a court grants a special motion to dismiss, it shall award the non-moving party costs and reasonable attorney's fees, including those incurred for the special motion. Moreover, the award of attorney's fees is mandatory. I can't even imagine what her bill is so far. Here, Ms. Reed easily meets her burden of establishing that all of the alleged activity is protected petitioning, and plaintiff cannot meet their burden to establish that her petitioning activity was devoid of any reasonable factual support or any arguable basis in the law. As a result, the court should allow Ms. Reed's motion and award reasonable attorney's fees and costs. 2, the court should dismiss plaintiff's claims against Ms. Reed pursuant to the anti-SLAPP statute. I just want to point out that this is very interesting because the anti-SLAPP motion that we have already read is in the reverse. The defendants, many of whom are the same people here, except not Colin Albert, that Karen Reed sued, the case was moved to federal court by the Haas defendants. The Haas defendants have moved for dismissal based on the anti-SLAPP statute by saying that everything that they said and did was to the police in furtherance of a police investigation, and therefore the case should be thrown out. We're protected. The case should be dismissed. Karen Reed's opposition to that says, okay, not only did you say some things, you also did some things. So there are some acts that you did behind the scenes, like trying to frame me and cover things up and point the finger at me instead of you, and collude together to do that. That is unprotected under anti-SLAPP. And everything that they are alleging against Karen Reed are things that she said about them. And they're saying that she and Aidan Kearney civilly conspired against them. So it's a little bit different. And we're looking at it now from the other point of view. I hope that makes sense. Okay. First stage, plaintiff's claims are based solely on petitioning activity. At the first stage of the anti-SLAPP analysis, a court need only conduct a facial review of a special motion opponent's pleading to identify which factual allegations serve as the basis for a particular claim. However, the court can consult documents in the anti-SLAPP record to determine whether these factual allegations fall within the statutory definition of petitioning activity. Wait, who died? Who died? Bonnie who? Not Bonnie Raitt. Don't you tell me Bonnie Raitt died. Who died? I gotta wait to find out. Martine, living in Spain. Bonnie Tyler. Okay. It's not Bonnie Raitt. Sorry, I mean RIP Bonnie Tyler, but not familiar. Okay, moving on. The anti-SLAPP statutes defines petitioning expansively. Indeed, the definition of a party's exercise of its rights of petition in the anti-SLAPP statute is very broad and includes several elements that squarely apply to Ms. Reed's speech and actions here, including any written or oral statement made in connection with an issue under consideration or review by a legislative, executive, or judicial body, any statement reasonably likely to encourage consideration or review of an issue by a legislative, executive, or judicial body, any statement reasonably likely to enlist public participation in an effort to effect such consideration, and any other statement falling within constitutional protection of the right to petition government. Oh, please. And here in footnote 2, it's repetitive, but the entire statutory definition is located here in footnote number 2, if you would like to read it, which continues on page 7. Additionally, in order to determine if statements are petitioning, courts consider them in the overall context in which they were made. A facial review of the complaint shows that plaintiff's claims against Ms. Reed are based on her statements, all of which meet the expansive and very broad definition of petitioning activity. Count 1 is based on petitioning activity. At count 1, plaintiffs allege that Ms. Reed repeatedly published false statements asserting, or reasonably understood as asserting, that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder. Plaintiffs do not identify the allegedly defamatory statements in count 1. However, in the complaint as a whole, plaintiffs identify a handful of allegedly false statements by Ms. Reed about the plaintiffs. And these too are bullet pointed. Stating to investigating officers prior to her arraignment that Brian and Colin Albert beat up Mr. O'Keefe, which statement was released to the public during a judicial hearing in April of 2024. Next, stating in a discovery motion during her first prosecution that Brian and Colin Albert were responsible for Mr. O'Keefe's death and that Ms. McCabe was the mastermind who covered it up. Forwarding the court-filed motion to Mr. Kearney, who then published it, telling Mr. Kearney through an intermediary that Brian, Nicole, Chris, and Julie Albert all testified to a grand jury that Colin Albert was present at the Alberts' home at 34 Fairview. Telling reporters during her second trial that Ms. McCabe's testimony at the trial was perjured and that she was lying, telling a podcast on January 12th, 2026, that Mr. O'Keefe entered the Alberts house, quote, and much sooner than later met his demise, and that someone in the house killed John O'Keefe. All of these statements by Ms. Reed constitute petitioning activity. First, the statement Ms. Reed made to investigating officers was after she had been arrested and was trying to convince the police officers that the Alberts, rather than her, were responsible for Mr. O'Keefe's death. That body cam footage, it's the only, some of the only body cam footage that was introduced at the trial, and it is Yuri Buchanan wearing a body cam in the barracks, wherever it was that they brought Karen Reed after they upgraded her charges to murder. And arrested her without calling her attorney. They knew she was represented. This was in June of 2022 when the charges were upgraded to murder. And she says something like, we're all in on the same joke, right? John was pulverized. And he was beaten up by Colin and Brian Albert, something like that. I can't remember the exact quote right now. But she is talking to Yuri Buchanan. It's his body cam. He's sitting behind a computer, so you can't see him. In her pajamas. Yeah. Therefore, it was an oral statement made before an executive body reporting a violation of law by the Alberts and thus constitutes petitioning activity. I remember too, that was in June 2022. That was before Aidan Kearney ever was involved in this case. Now here's a case that says reporting violation of law to officials is petitioning activity. Second, the statements made in the discovery motion are similarly written statements made before or submitted to a judicial body. Sharing the court filed document is itself petitioning activity. And here's a case from 2005. Concludes that the statements made to press that were essentially mirror images of statements made at a disciplinary hearing were also petitioning activities. Ms. Reed did not have a commercial motivation, footnote 3, when she shared the motion with Mr. Kearney. Footnote 3 says, notably, the complaint only alleges that Mr. Kearney, not Ms. Reed, acted in the course of trade and commerce and violated the Massachusetts Unfair Trade Practices Act. That's true. Instead, she hoped he would publicize it so that the public at large would understand that she had been framed and would pressure the Commonwealth to drop her prosecution and instead prosecute the true perpetrators. Been screaming that from the rooftops for a long time. The complaint itself alleges that Ms. Reed's purpose in sharing information with Mr. Kearney was to widely disseminate the information to cast suspicion on the plaintiffs and away from Reed. The statements made in the discovery motion shared with Mr. Kearney were made to influence, inform, or at the very least, reach governmental bodies, either directly or indirectly. There is thus a plausible nexus between the statement and the governmental proceeding. Right. She was defending herself. She wanted the truth out there. She wanted people to report on it. It's unfortunate that YouTube did most of the work and the mainstream media wouldn't pick it up. And here we are. 4 years later, still talking about it. And therefore, they were made in connection with an issue under consideration or review by a legislative, executive, or judicial body, or any other governmental proceeding, and were reasonably likely to enlist public participation in an effort to affect Ms. Reed's first prosecution and then her retrial. Right. The same is also true of Ms. Reed's statements to reporters that Ms. McCabe had perjured herself during her trial testimony in Ms. Reed's second trial. Ms. Reed made the statement on the courthouse steps immediately after the conclusion of that day's proceedings. The purpose was to widely disseminate to the public her defense to the prosecution that the McCabes, the Alberts, and Higgins were responsible for Mr. O'Keefe's death. The goal was to galvanize public support and to pressure the Norfolk County District Attorney's Office to drop the prosecution or to refrain from a second trial in the case of another mistrial. It worked. It worked. Remember how many people were standing outside Norfolk Superior Court on the day of Karen Read's acquittal? Finally, in 2025. Either all of those people were brainwashed by Turtle Boy and people like me, or they actually did the work, watched the trials, read the documents, investigated it on their own, because nobody's smarter than my chat. You guys have common sense, logic. And you know a lot about physics, medicine, science, injuries. But they want you to think everybody was brainwashed by paid actors. Paid actors. Thus, the allegedly tortious statement is similar to the statements made to the Boston Globe in Blanchard versus Stewart Kearney Hospital, 2017 case. In Blanchard, a hospital president made statements to the Boston Globe at the time the Commonwealth was considering revoking a hospital unit's operating license because of suspected abuse cases. The SJC held the president's statements were petitioning activity because the statement communicated to readers, likely included some of the licensing decision makers, that progress was occurring at the hospital and that its license to operate the unit should not be revoked. The statements were petitioning activity made in connection with the ongoing licensure proceeding because, one, licensure, they directly related to the Commonwealth's then pending investigation. Two, was in furtherance of the objective of the hospital's petitioning activity, the preservation of the hospital's license. And three, were issued in a manner that was likely to influence, or at the very least, reach the Commonwealth because it was made in the widely circulated Globe. And four, the timing of the statements indicated a nexus with the investigation because they were made while the investigation was pending. Additionally, the SJC has ruled that speech and advocacy designed to foment public participation around a pending judicial proceeding constitutes protected petitioning under the anti-SLAPP statute. It's also important to note that while the Commonwealth was aware of all these things that Karen Read was saying, it didn't make one bit of difference because they made the decision to try her again on the same day that the mistrial was declared in June of 2024. I don't remember if it was June or July. One of them was June, one of them was July. If I'm wrong, you'll tell me. But I do believe that the decision to prosecute Karen Read for a second time was made the same day as the mistrial. If I'm wrong, let me know. I think Adam Deitch said that in the interview that we looked at yesterday, right? Similarly here, Ms. Read's statements to reporters that McCabe was untruthful directly related to the then proceeding prosecution, supported Ms. Read's petitioning activity in that proceeding to be acquitted, to have the claim dismissed, and to avoid a retrial in the case of a hung jury, was issued in a manner that would be widely reported as it was covered by local television news channels. It was within hours. Yeah, that's what Glamis News, it was within hours, right? Okay, so the mistrial was in July of 2024. And I think it was June 18th of 2025, because I remember we just celebrated the 1-year anniversary of Karen Read's acquittal within hours. And was issued while the prosecution was still pending. The statement was thus petitioning activity. "18-wheeled Maligator crate." I hope you're not driving and typing. It says Lally said it immediately after the mistrial was declared. June 18th, 2025 was the day of her acquittal, right? They started reading the verdict at 3 p.m. And did we ever get a final count on how many people were outside that courthouse? Because you will never, in my opinion, see anything like that again. Maybe you will, because all of you are now fiercely advocating for justice, and not just this case, but many others. Finally, Ms. Reed's statements in the January 2026 Rotten Mango podcast were also petitioning activity because they were made in connection with an issue under consideration or review by a judicial body. In particular, even though the underlying prosecutions had ended, Ms. Reed was already defending a wrongful death claim brought by Mr. O'Keefe's family in Plymouth Superior Court, which had been filed in August of 2024. Ms. Reed's statements on the podcast were related to her case. They were intended to be widely publicized. Footnote 4, which says the Rotten Mango podcast has over 6 million subscribers at YouTube, making it one of the most widely distributed podcasts. If anybody wants to check or can let me know how many views the Karen Reed episode on Rotten Mango has as of today, that would be an interesting thing to know. They were intended to keep her defense publicized and to persuade any judge or fact finder that she should not be held liable for Mr. O'Keefe's death. And they were intended to convince the O'Keefe family that it had sued the wrong party and should drop its suit. Thus, like her other statements with a plausible nexus to an ongoing proceeding, the overall context in which they were made shows that Ms. Reed's statements on Rotten Mango were made in connection with an issue under review by a judicial body and was reasonably likely to enlist public participation, and therefore 1.9 million. Thank you, Marvin. Thanks everybody who did the Lord's work and went over and looked. I think Minnie might have been first. 1.9 million views. Thus, like her other statements with a plausible nexus to an ongoing proceeding, the overall context in which they were made shows that Ms. Reed's statements on Rotten Mango were made in connection with an issue under review by a judicial body and was reasonably likely to enlist public participation and therefore constitute petitioning activity. Two, the other non-defamation counts are all based on Ms. Reed's statements that constitute petitioning activity. In counts 3, 4, 6, 7, and 9, plaintiffs assert various non-defamation claims against Ms. Reed. They should also be dismissed under the anti-SLAPP statute because they are based on the same statements that underlie count 1, all of which fall under broad definition of petitioning activity in the anti-SLAPP statute. A, the aiding and abetting counts 3, 7, and 11. Counts 3, 6, and 9 all allege aiding and abetting liability for 3 discrete torts allegedly committed by Mr. Kearney: defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. They all allege the same activity, aided and abetted Mr. Kearney's tortious conduct, that Ms. Reed continuously and intentionally provided defendant Mr. Kearney with non-public and or confidential information about her criminal case. The complaint's only allegations about Ms. Reed sharing non-public and or confidential information with Mr. Kearney are in paragraphs 28 and 49 to 51, all of which constitute, say it with me now, petitioning activity. Paragraph 28 alleges that Ms. Reed forwarded her April 12th, 2023 discovery motion, which had non-public documents attached to it. But as discussed above, the discovery motion is a court pleading and thus a written statement made before or submitted to a judicial body. In other words, it is petitioning activity. Paragraph 49 alleges that Ms. Reed falsely told Mr. Kearney through an intermediary that the Alberts provided grand jury testimony that Colin Albert was at the Alberts house the night of Mr. O'Keefe's death. Paragraph 50 alleges that Ms. Reed told Mr. Kearney, quote, "Not public. The feds have been involved longer than anyone is likely guessing." Paragraph 51 alleges that Mr. Kearney published an audio file capturing Ms. McCabe's 911 call the morning Mr. O'Keefe's body was found and implies the file came from Ms. Reed or Ms. Reed's legal team. Yeah, do you remember the 911 call? I do. There's the man passed out in the snow. There's a guy unresponsive. Can you send someone? Can you send someone? How long has he been there? I don't know. He got out of the car and I don't know. I think he's gone. I think he's dead. I think he's dead. I think he's gone. As with the allegedly defamatory statements made directly by Ms. Reed, all of these statements that plaintiffs say constitute aiding and abetting defamation were petitioning activities because they were made in connection with an issue under review by a judicial body and reasonably likely to enlist public participation in an effort to effect such consideration. Like the alleged direct defamation underlying count 1, there is a plausible nexus between these statements and the prosecution. They were made while Ms. Reed was being prosecuted and, as the complaint alleges, were made for the purpose of being widely disseminated to support Ms. Reed's defense. For example, see paragraph 48, which says, statements forwarded to Mr. Kearney, quote, so that Mr. Kearney could selectively publish for the purpose of casting suspicion on plaintiffs and away from Reed. See also paragraph 67, alleging Ms. Reed used Mr. Kearney as a tool to seed the public discourse with defamatory material. B, the emotional distress counts 4 and 7. Counts 4 and 7 allege intentional and negligent infliction of emotional distress based on Ms. Reed's alleged campaign of false and outrageous statements about plaintiffs. See complaint paragraph 173. Negligent infliction of emotional distress count is based on Reed's campaign of outrageous, cruel, and malicious lies. The emotional distress claims appear to be based on the same statements and conduct underlying the direct defamation count and the aiding and abetting counts. Therefore, for the reasons outlined above, these counts are also premised on Ms. Reed's petitioning activity. Citing some case law, plaintiff's claim for negligent infliction of emotional distress dismissed because it grows out of the same nucleus of operative facts that spawn her defamation claim. Count 4 confirms that. It alleges Ms. Reed orchestrated a coordinated campaign to falsely accuse the plaintiffs of murder and conspiracy to frame her and funneled false statements to Mr. Kearney for maximum public dissemination. See complaint paragraph 175, footnote 5, which reads, footnote 5, count 4, the IIED claim, also alleges that Ms. Reed hired a private investigator previously associated with Harvey Weinstein to confront the plaintiffs, right? Who's pandering to the media now? As explained infra, part 2C, this allegation does not support an IIED claim because there's nothing extreme and outrageous about hiring a private investigator to interview someone. There's no allegation that any of the plaintiffs were aware the private investigator was previously associated with Harvey Weinstein. And there are no allegations the investigator did anything beyond try to speak with Higgins. Every good defense firm has a really, really good PI on retainer or on speed dial or in-house. Oh, please. As does any good plaintiff's firm. In other words, the alleged purpose of Ms. Reed's statements and communications with Mr. Kearney was to widely disseminate her defense that plaintiffs were responsible for O'Keefe's death. Given this purpose and the widespread public dissemination, the statements and communications were petitioning activities. They were made in connection with an issue under review by a judicial body and reasonably likely to enlist public participation in an effort to effect such consideration. C, and then it cites a case. The civil conspiracy, count 10. Plaintiff's final claim against Ms. Reed, count 10, alleging civil conspiracy, is also solely based on petitioning activity. The complaint alleges that the conspiracy between Ms. Reed and Mr. Kearney was, quote, an agreement to defame the plaintiffs and to inflict severe emotional distress on them. Again, the claim is based on the same allegedly defamatory statements and communications. They were made to widely publicize Ms. Reed's defense while proceedings against her were pending in an effort for an acquittal and or to pressure the Commonwealth to dismiss the case and refrain from a retrial in the case of another hung jury. Like the other claims, therefore, count 13 is based on petitioning activity. B, second stage. Plaintiffs cannot show Ms. Reed's petitioning activities were devoid of any reasonable factual support. Because all of the plaintiff's claims against Ms. Reed are based on petitioning activity, to avoid dismissal under the anti-SLAPP statute, the burden shifts to the plaintiffs to show by a preponderance of the evidence that Ms. Reed's petitioning activities were devoid of any reasonable factual support or any arguable basis in law and caused actual injury to them. As the SJC has stated, it's a difficult task, and even the submission of an affidavit showing a material dispute of fact does not suffice to show the petitioning activity was devoid of any reasonable factual support. Footnote 6, which talks about some case law, if you would like to read it. In this case, plaintiffs cannot clear this high bar because there's ample evidence supporting Ms. Reed's statements that plaintiffs caused Mr. O'Keefe's death. Oh, it says Ms. O'Keefe. There's a typo there. I'm going to substitute with Mr. because we know it's Mr. Plaintiffs caused Mr. O'Keefe's death and then tried to frame her. Of course, the simple and dispositive answer to whether Ms. Reed's defense that she did not kill Mr. O'Keefe and that multiple parties attempted to frame her is devoid of any reasonable factual support or arguable basis in law was answered already on June 18th, 2025, when a jury acquitted Ms. Reed of all charges relating to the death of Mr. O'Keefe. And this is interesting. There's a 2002 case, Faber v. Walton, which says, holding that judgment in favor of party to litigation is conclusive evidence that the petitioning activity was not devoid of any reasonable factual support or arguable basis in law. Baker v. Parsons, 2001, noting that it is not enough for plaintiff to show that defendant's alleged petitioning activity was based on an error of law. He must show that no reasonable person could conclude that there was a basis in law for his position. Well, you're all reasonable people here. Do you think there was a reasonable basis for Karen Reed to say what she did about the people in the house being responsible for the death and or cover up of John O'Keefe and the framing of Karen Reed? I'll leave it to you, reasonable people. There is no need for this court to reinvent the wheel here. Putting that analysis aside for the moment, however, the evidence supports Ms. Reed's position. The evidence supporting Ms. Reed's position remains overwhelming. Below is a sampling. There's over 7,000 reasonable people here. Some of you may be trolls and hate watchers, but the majority of you, I think, do realize that John O'Keefe was not hit by a car because injury science, physics, medicine, experts. Here's a sampling of the overwhelming evidence supporting Ms. Reed's position. Bullet pointed again. Ms. Reed did not strike Mr. O'Keefe with her vehicle. The Massachusetts chief medical examiner testified that Mr. O'Keefe's injuries were not consistent with a vehicle strike, but rather a physical altercation. See the testimony of Dr. Irene Scorti-Bello as Exhibit 1. This is the first exhibit. There's a lot of exhibits attached to this motion. Most of them are testimony. Mr. O'Keefe did not show signs of a physical altercation before Ms. Reed dropped him off, and he and Ms. Reed did not have such an altercation before she dropped him off at the Albert's house. And this is now, they're citing Karen Reed's affidavit, which we are going to read right after this. Next, Mr. O'Keefe also suffered a contre-coup wound on the back of his head, which is consistent with falling on the ridge surfaces present in the Albert's home garage. See the testimony of Dr. Irene Scorti-Bello. Mr. O'Keefe also suffered dog bite wounds, and the Albert's German Shepherd had a history of aggression. See the testimony of Dr. Irene Scorti-Bello. Mr. O'Keefe's phone was at some point inside the Albert's home. See testimony of Ian Whiffen. Notice how they're using all of the Commonwealth witnesses against them, against these Haas plaintiffs. These aren't Karen Reed's hired guns. Irene Scorti-Bello is a Commonwealth witness. She works for the Commonwealth. Ian Whiffen is the Commonwealth's witness. Moving on. Ms. McCabe had used her phone to search at 2:27 a.m. on January 28th. How long? It was really, wasn't it January 29th? Oh, better fix this one. How long it takes for a person to die in the cold. See the testimony of Richard Green. Exhibit 4. That was Karen's expert. Wild, too. In the recent document dump that came out, they went and pulled like every police report they could find. Maybe it was just one, but it was long, about Richard Green. Apparently he got into a bar fight, I think around the time that his father died, somewhere in Florida. That was part of their discovery. Nice, right? In the early morning hours of January 29th, 2022, Mr. O'Keefe's body was not present in the spot it was later found, as Brian Loughran testified. See testimony of Brian Lucky Loughran, Exhibit 5, to Seligson affidavit. Put some four-leaf clovers in the chat for Lucky. We love Lucky. Instead, a Ford Edge was parked in the spot, although it was not present when Ms. Reed dropped off Mr. O'Keefe. Brian Albert owned a Ford Edge at the time. See Brian Albert trial testimony, Exhibit 6. Dr. Elizabeth LaPosada, the former chief medical examiner for Rhode Island and a professor at Brown University, opined that Mr. O'Keefe died from a massive skull fracture that was inconsistent with a vehicle strike. See Exhibits 30 to 32. Appended to the affidavit of Jeffrey Pyle submitted in support of defendant Aidan Kearney's special motion to dismiss, which we don't have yet. Dr. LaPosada further testified that due to the abrasions on the back of Mr. O'Keefe's head, the injury was most likely caused by falling backward onto a ridge surface, and she observed no evidence of any ridge surface where his body was found. She also testified that she found no evidence that Mr. O'Keefe suffered from hypothermia. No hypothermia. She testified further that the wounds on his right arm were consistent with an animal bite or claw marks. Well, I should point out here that we don't really know where John O'Keefe's body was found because it was never marked. It's never marked. You know, it was snowing. They don't have evidence markers there, I guess. So nobody really took measurements of where the body was or did a chalk outline or any outline or even put crime scene tape up to secure the scene all day because, you know, it was windy and whatnot and incoming nor'easter and such. In addition, there's ample evidence that plaintiffs have made material misrepresentations in previous sworn testimony, rendering suspect any sworn statements offered in this case. Dun, dun, dun. These misrepresentations include, well, before we get to the misrepresentations, I haven't seen the chat in a long time because I'm just over here reading the papers. Let me thank some people. New members, welcome. Lady. Commonwealth Not Well, welcome. Deb and Bentley, thanks for being here for 19 months. Thank you for your 10. Diana, ER Trauma RN, I love you so much more. You're a nurse. You know how much we love you. Thank you so much. Thank you, Helena, for tuning in from Sweden and for your super sticker. You're amazing. Julie says, oh, she's complimenting me. That is very sweet of you. She says, there's a great color on me. Thank you so much, Julie, for your 10. Kristen became a new member. Welcome, Kristen. A lot of Kristens in the chat. A lot of Kristens, Kirstens. Angel the Aussie said, I've been meaning to ask for ages. Did you paint your YouTube 100,000 play button in Tiffany blue? If yes, genius. If no, it's just the reflection, genius. No, it's the reflection. The walls are Tiffany blue. Yes, I wouldn't paint it. Thank you, though. XOXO. And Nancy's been here for 8 months, and she's amazing. Thank you, Aunt Nancy. Gigi's here. She's busy right now. She's engraving the silver clinks because that's going to be season 4. So she's getting the props ready, and she gifted 5 memberships because she's awesome. V Kinds 80 says, question, if Judge Gilday makes a judgment in one of the cases and it is entered, does this affect any or all of Karen's cases? You're going to have to be more specific because I'm not sure what you're asking. If he makes a judgment in this case, dismissing Karen's case based on anti-SLAPP, then she wins and this case is over. If you're talking about the car accident case, the judgments that he makes only affect the case in which the judgment is made, if that makes sense. I think that's your question. So it doesn't carry over into the other cases because there's a lot of cases. There's the one in federal court. There's two in front of Judge Gilday right now, the wrongful death car accident case that didn't happen. And this one, the defamation case. So the rulings that he makes in each case only affect the case in which the ruling is made. Thank you for your 5. I love you too. Dolo, Dolo. And thank you for listening and for taking an interest. I appreciate you. Every single one of you so much. Please smash the like button. Do all the things that YouTube likes. You know what they are. All right, moving on. These misrepresentations include Brian Higgins. Brian Higgins is supposed to be deposed today. I wonder if he showed up. I don't know. Did Brian Tully show up yesterday? I heard that he did, but you know, that's like internet gossip. So I don't know for sure. Tully had his deposition yesterday, allegedly. Higgins was supposed to be deposed today. That's why Chris Maddie wanted to be admitted pro hoc vice on an emergency basis so that he could do Brian Higgins' deposition with him today. Paid the $355. Glamassu says that Higgins did show up. Good. I hope he can get all of this off his conscience. We'll see. We'll see what happens. Hold on. Oh, please. Brian Higgins. Mr. Higgins originally told police that he went to the Canton Police Department on the morning of January 29th to do administrative work in the middle of a snowstorm. And here's his testimony attached as Exhibit 13. Mr. Higgins then told the grand jury and said he went to the Canton Police Department to move cars around. Yet later at trial, video evidence showed Higgins moving a large parcel from one vehicle to another, disappearing into his office, and then spending a period of time in another unseen area of Canton PD. Then finally exiting Canton PD. See the Canton Police Department Incident Report, Exhibit 10 to Seligman's affidavit. Also, if you believe Kelly Dever, Brian Higgins disappeared into the Sallyport with Ken Berkowitz for a wildly long time. But I think she admitted that that was a false memory. So I'm just pointing it out, although they wouldn't cite that here because she said it was a false memory. Mr. Higgins testified that he didn't speak to anyone after leaving the Alberts house until he was notified of Mr. O'Keefe's death in the morning of January 29th. However, evidence at trial showed that he and Brian Albert communicated by phone at 2:22 a.m. that morning before Mr. O'Keefe's body was found. See Higgins Albert call logs, Exhibit 2 to Selig's affidavit. Yeah, what happened to that duffel bag and what was in it? Inquiring minds. Maybe they'll ask him about it today at his deposition. Do you think his deposition will take more than one day? Who do you think is doing his deposition? Who do you think is conducting it? Who do you think is lead? Oh, so many questions. Did Al Jackson fly in for it? Here are the misrepresentations of Nicole and Brian Albert. See how they're very careful to not say that they lied? They're just misrepresentations. Nicole and Brian Albert together as a couple. Here's our little mascot, little rubber ducky. Well, it's a little plush ducky, but it does squeak. Sorry if this annoys your pets, but it's cute. On January 29th, they told Sergeant Lank, this is Nicole and Brian Albert, Sergeant Lank bit a man. Did you know that? He bit a man in defense of the Alberts all the way back in the early aughts. I think it was the early aughts, maybe like 2002. He bit one of the Lopalato brothers on behalf of Chris Albert. Michael Lank bit a man. It's true. It's true. He's been the fixer, the Ray Donovan of the Albert family for decades. On January 29th, they told Sergeant Lank that their daughter, Caitlin Albert, was only briefly at the Alberts house and left around 12:15 a.m. See Canton Police Department at page 8, Exhibit 10, to Seligson affidavit. However, Caitlin was later interviewed by MSP and said she was the last to leave 34 Fairview. I guess nobody gave her the timeline. See Massachusetts State Police interview of Caitlin Albert, Exhibit 9, to Seligson affidavit. Trial testimony by all the Haas defendants confirmed Caitlin was the last to leave the Alberts house at around 2 a.m. See transcript trial testimony of Jennifer McCabe, Exhibit 11. Nicole Albert told police she was asleep until Ms. McCabe came into her bedroom just before 7 a.m. on January 29th. See her trial testimony, Exhibit 14. However, call logs show a 38-second answered call from Jen to Nicole at 5:07:21 a.m. See Jennifer McCabe phone records attached as Exhibit 12. Brian Albert testified that he didn't make any calls during the night of January 29th, but call logs showed activity between him and Brian Higgins at 2:22 a.m. See Brian Albert testimony. Yes, Brian Albert said that he and Nicole were, having a little sexy time. And that, I don't know who called who first, but it was a butt dial and then a butt answer at 2:22 a.m., 5 minutes before Jennifer McCabe's phone Googled Hoslong to die in cold. That's my word. Those are my words. It's not in the papers. Jennifer McCabe. Ms. McCabe falsely identified herself as Nicole to interviewing FBI agents and falsely told them that she had not made any phone calls in the brief period after the agents first showed up and then returned for questioning. See her trial transcript. After being threatened with the penalties of lying to agents from another organization, Ms. McCabe admitted to calling her husband, Brian Albert, Peg O'Keefe, and Adam Lally. See Exhibit 11. Ms. McCabe omitted during her trial testimony that she went to Sergeant Lank's house on January 30th until the defense presented her phone's location data. See Exhibit 11. She also testified that she drove straight to Sergeant Lank's house from the O'Keefe's house, but her path of travel showed she went directly to Sergeant Lank from her own house after stopping at the Alberts house. Oh yeah, she had a whole lot of excuses for that. She also denied ever stopping at the Alberts house, but the phone data at trial revealed a 5-minute stop on the way to Sergeant Lank's residence. Wonder if that coincided with the text messages that said, "Don't text about it, we'll find out more tomorrow." Inquiring minds. Ms. McCabe falsely told first responders that Ms. Reed said, "Could I have hit him?" She later testified at trial. Ms. Reed said, "I hit him, I hit him, I hit him." That's why we call her Jenny 3 times, because everything was done in threes. I hit him, I hit him, I hit him. Besides the physical evidence and the evidence that plaintiffs have made numerous besides the physical evidence and the evidence that plaintiffs have made numerous material misstatements in previous testimony, plaintiffs have also destroyed multiple pieces of evidence with the knowledge that the evidence would be relevant to any prosecution in later civil litigation. Mr. Higgins and Brian Albert destroyed their phones after a court order to preserve them. See testimony of Brian Higgins. "Well, I don't know if I did it, but if I did it, I might have cracked the SIM card. I might have put it in 2 different dumpsters on a military base because it's just like a cut through to where I live down the Cape. Because I go to the military base because I got discount JMO, no big whoop, whatevs." Even though she didn't destroy her phone, Ms. McCabe deleted many of her texts, as well as the 2:27 a.m. Google search. See testimony of Richard Green. At the very least, the court should draw an adverse inference that the deleted information would not have supported plaintiff's statements that they had nothing to do with O'Keefe's death. See Fletcher, 2002 Massachusetts case, where evidence has been destroyed or altered by persons who are parties to the litigation, and another party's ability to prosecute or defend the claim has been prejudiced as a result, We have held that a judge may exclude evidence to remedy that unfairness. Given all of this evidence, plaintiffs cannot carry their burden at the second stage of the anti-SLAPP analysis to establish that Ms. Reed's statements were devoid of any reasonable factual support. Dismissal of plaintiffs' claims against Ms. Reed is therefore appropriate under the anti-SLAPP statute. Yes, there were but dials and but answers, both. Plaintiffs, and also Jennifer McCabe, made several but dials to John O'Keefe, and somehow she butt dialed and then butt hung up before his voicemail ever picked up, which is crazy because you know what happens if you butt dial someone and they don't pick up. I mean, you have to have 2 interactions with your phone to call and then to hang up, right? Roman 2. Plaintiff's claims do not state a claim for relief and should be dismissed under Rule 12b6, which is a Massachusetts civil rule. Even if the court denies the special motion to dismiss, plaintiff's claims should still be dismissed pursuant to 12b6 for numerous reasons. Count 1, defamation. Count 1 alleges defamation, which requires proof that the defendant was 1, at fault, for 2, the publication of, 3, a statement regarding the plaintiff, 4, capable of damaging the plaintiff's reputation in the community, which, 5, either caused economic loss or is actionable without proof of economic loss. 1, the plaintiff does not comply with the Civil Rule 8A because it does not specify the allegedly defamatory statements. Count 1 should be dismissed because plaintiffs do not identify which statements made by Ms. Reed allegedly constitute defamation. Instead, they state the, quote, complaint does not include each and every example of Reed and Kearney's defamatory statements and conduct. Count 1 itself does not identify any statements apart from the generic allegation that Ms. Reed made, quote, false statements asserting or reasonably understood to be asserting that the plaintiffs were responsible for the murder of O'Keefe and a cover-up of their purported role in the murder. This vague pleading runs afoul of Civil Rule 8A's short and plain statement requirement because it does not provide Ms. Reed with notice of the basis of plaintiff's claims against her. See a 2008 case from Massachusetts, which says a complaint must, however, contain a short and plain statement of the claim, which affords fair notice to the defendant of the basis and nature of the action against him. The complaint's vagueness makes it impossible to formulate a response to the allegations. For instance, the complaint alleges that Ms. Reed's alleged, quote, defamation campaign began on April 18th of 2023. Yet, the complaint also alleges that Ms. Reed knowingly and falsely told police before her second arraignment, footnote 7, which says, Ms. Reed made the statement in June of 2022. I was right about that. That's the statement on body cam of Yuri. The complaint also alleges that Ms. Reed knowingly and falsely told police before her second arraignment that Brian and Colin Albert beat up Mr. O'Keefe and that she was not responsible for his death. The complaint also refers to statements made in a discovery motion filed by Ms. Reed's attorney, which was forwarded to Mr. Kearney on April 12th of 2023. That's what triggered him. That's what triggered him to take an interest in the case, was the 227 search. He said that many times, and I think his first article was published on something like April 18th, 2023, which would have been 6 days after he read the allegations about the 227 search. And he's like, If these statements are the allegedly defamatory statements underlying count 1, they are subject to dismissal because they were made more than 3 years prior to the complaint's filing on April 16th of 2023. That's the statute of limitations, 3 years from the date of publication. Here's a 2014 case, which says defamation claim accrues when defamatory statement published to third party. There you go. The statements made in the discovery motion are also absolutely privileged under the litigation privilege. 1991 case, which says statements made in the course of a judicial proceeding which pertain to that proceeding are, of course, it says, of course, absolutely privileged and cannot support a claim of defamation, even if uttered with malice or in bad faith. So there it is. Whatever's in the motion, protected by litigation privilege. The other statements by Ms. Reed identified in the complaint similarly do not constitute actionable defamation as explained in Part 2. However, apart from the statement listed in the complaint, Ms. Reed cannot fully respond to Count 1 to the extent it relies on other statements that are not included in the complaint. For that reason, Count 1 should be dismissed because it does not provide a short, plain statement of the defamation claim. Now, remember how many footnotes there were in that complaint? I do. I think there was like 60 footnotes. I think it took us 4 parts to get through because we clicked on every hyperlink and we watched every single video that they wanted us to watch. And many, many of them were in support of the defense in this case. Crazy. 2, nearly all of Ms. Reed's actual statements listed in the complaint are not actionable defamation as a matter of law. As explained above, Count 1 cannot be premised on the June 2022 statement by Ms. Reed and the April 12, 2023 statements made in the discovery motion filed in Norfolk Superior Court because the claims would be untimely and barred by the absolute litigation privilege. Other statements by Ms. Reed listed in the complaint are also not actionable defamation. A, paragraph 49, statement about Albert testimony to grand jury. Paragraph 49 alleges that Ms. Reed told Mr. Kearney through an intermediary that Brian Albert and other non-plaintiff members of the Albert family testified to an investigating grand jury that Colin Albert was at the Albert's house prior to O'Keefe's arrival. This statement, even if false, is not defamation. A defamatory statement is one that discredits the plaintiff in the minds of any considerable and respectable segment in the community. A statement that Brian Albert correctly told a grand jury that Colin Albert was at the Albert's house does not discredit Brian Albert or injure his reputation. Paragraph 50, statement about feds involvement. The feds. Paragraph 50 alleges that Ms. Reed told Mr. Kearney through an intermediary that the feds have been involved longer than anyone is likely guessing. This statement is not actionable because even if false, it is not of and concerning the plaintiff. Right. Paranoid much? Right? They're assuming that the feds' involvement is directly related to them. Huh. Interesting. In other words, the statement does not refer to the plaintiffs, and no person could reasonably understand the statement referred to the plaintiffs. In addition, the statement is not one of fact, but rather an opinion about the length of federal involvement. The FBI ice cream truck. See, prior case cited above from 2020 that says to be actionable, the statement must be one of fact rather than opinion. Paragraph 51, January 29th, 2022, voicemail excerpt. Paragraph 51 implies that Ms. Reed or her legal team provided an excerpt of a voicemail Ms. Reed left Mr. O'Keefe the morning of January 29th, 2022, which captured Ms. McCabe's call to 911. There's no allegation, however, that Ms. Reed made any statement of or concerning Ms. McCabe or the other plaintiffs, and no allegations that any statements in the voicemail were false or injurious to plaintiff's reputation. D, paragraph 58, Yannetti text regarding HPO. The next statement in the complaint attributes to Ms. Reed or her lawyers in paragraph 58, which alleges that Ms. Reed's attorney, I should say, Mr. Yannetti, texted Mr. Kearney that the Stoughton District Court had denied an ex parte harassment prevention order Ms. McCabe had sought against Mr. Kearney. This true statement cannot be defamation because it's true, and also does not tend to discredit Ms. McCabe or injure her reputation. Footnote 8, which says, the statement relaying the denial of the HPO is also privileged under the fair report privilege. See Jones versus Taibbi, 1987. There's a well-established privilege to publish reports of judicial, legislative, or other official proceedings. Paragraph 75, Facebook group hosting and posts. Paragraph 75 alleges that Ms. Reed was co-administrator of a Facebook group that, quote, became a feeding ground for defamatory and harassing posts made regarding the plaintiffs. But the paragraph does not allege what statements were made, when and by whom, nor does it allege that Ms. Reed was responsible for any of these third-party posts. If Ms. Reed did not make or publish the unidentified statements, she did not defame the plaintiffs. Now, some pretty obvious case law that says in order to prevail, the plaintiff must establish that the defendant published a false statement. To the extent plaintiffs are alleging that Ms. Reed's administration of the Facebook group constitutes defamation, she is immune under Section 230 of the Communications Decency Act, which is a federal statute. Quote, courts analyzing and applying the CDA have consistently held that distributing, sharing, and forwarding content created and or developed by a third party is conduct immunized by the CDA. As for Ms. Reed's own statements on the Facebook page, the complaint does not allege that any were false, just that she shared confidential information regarding her criminal case that had not been previously known to the public. The complaint also does not allege that any of Ms. Reed's Facebook posts concern plaintiffs or injured their reputations. Without alleging these basic elements, any defamation claims premised on Ms. Reed's unidentified Facebook posts fail as a matter of law. Paragraph 115, statement by Jackson to Nightline. Paragraph 115 alleges that Ms. Reed's attorney, Mr. Jackson, said on an episode of ABC's Impact X Nightline show that, quote, there are people in that house that are actually responsible for his death and who murdered him. And there are others in that house that are covering up that murder. It also alleges that Mr. Jackson said that Ms. McCabe knew Mr. O'Keefe was murdered in the house and that his body was placed outside. Any defamation claim premised on these statements should be dismissed. The complaint does not allege Ms. Reed is vicariously liable for her attorney's statements. Even if it did, quote, principal's vicarious liability turns on whether the agent is liable. Thus, the complaint must plead that Mr. Jackson is liable for defamation, which requires an allegation he was at fault. And they didn't sue Alan Jackson. The complaint does not allege any fault on Mr. Jackson's part, whether negligence or recklessness or knowledge of falsity. Thus, the complaint does not sufficiently allege Jackson's liability for defamation and therefore fails to allege Ms. Reed is vicariously liable for Mr. Jackson's statements. I'm going to ask you to talk amongst yourselves for a second while I turn on the fan because it's getting a little bit warm in here. I'll be right back. Okay, I'm back. Paragraph 130, statement on January 12th, 2026 podcast. Paragraph 130 of the complaint alleges that Ms. Reed told the Rotten Mango podcast that Mr. O'Keefe entered the Alberts house. Entered the Alberts house and that someone in that house killed John O'Keefe. These statements do not support a defamation claim because they are not of and concerning any individual plaintiff. Instead, the statements are made generally about the group of people at the house, only some of whom were the plaintiffs. Defamation does not lie when a statement is made about a group, unless the size of the group or the context of the statement would make it reasonably understood the statement referred to the individual plaintiff. There can be actionable defamation when A defamatory statement applies to all members of a small group or when the statement refers to multiple members of a small group. Here, however, the statement is only about a single unnamed individual in a group, which does not support an inference. The statement referred to an individual member of the group. Citing some cases. B. The aiding and abetting and civil conspiracy counts 3, 6, 9, and 10 should be dismissed because the complaint does not allege how Ms. Reed substantially assisted Mr. Kearney other than making privileged statements. Counts 3, 6, and 9 allege that Ms. Reed aided and abetted Mr. Kearney's defamation, intentional infliction of emotional distress, and negligent infliction of emotional distress. To make out a claim against Ms. Reed for aiding and abetting Mr. Kearney's tortious conduct, plaintiffs must plead and prove, number 1, that Mr. Kearney committed the relevant tort, 2, that Ms. Reed knew he was committing the tort, and 3, that Ms. Reed actively participated in or substantially assisted in his commission of the tort. The civil conspiracy claim, count 10, has similar elements. There are 2 types of civil conspiracy. The first is a very limited cause of action that arises when the defendants, acting in unison, had some peculiar power of coercion over plaintiff that they would not have had if they had been acting independently. Plaintiffs do not allege this type of coercive conspiracy. Instead, they allege a concerted action conspiracy in which liability is imposed on one individual for the tort of another. This type of conspiracy, like an aiding and abetting claim, requires plaintiffs to plead Ms. Reed knew that Mr. Kearney's conduct constituted a breach of duty and gave substantial assistance or encouragement. Footnote 9, which says, both civil conspiracy claims and aiding and abetting claims in Massachusetts are based on Section 876B of the Second Restatement, which is a treatise about torts. Citing a couple of cases. Both types of claims, the aiding and abetting claims and the civil conspiracy claim, must be dismissed for 2 reasons. First, Ms. Reed cannot be held liable for aiding and abetting or conspiring to assist Mr. Kearney's tortious activity if he did not commit a tort. As explained in Mr. Kearney's motion to dismiss, Mr. We can call Aidan Mr. now. Mr. As explained in Mr. Kearney's motion to dismiss, the tort counts against him do not state a claim. What does that indicate to you? Are the attorneys working together collaboratively to come at this in defense of this? Seems that way. Unless Aidan filed his first and they got a hold of it. I don't know, but it seems like they might be collaborating. And there's nothing wrong with that, by the way. See paragraph 10 to 13 of defendant Aidan Kearney's memo of law in support of his motion to dismiss, which we don't have yet. Second, the complaint does not allege substantial assistance that would support aiding and abetting or conspiracy claims. The complaint alleges that Ms. Reed substantially assisted and encouraged Mr. Kearney when she continuously and intentionally provided defendant Kearney with non-public and or confidential information about her criminal case, and by funneling information and false statements to Mr. Kearney. Neither of these actions constitutes substantial assistance for Mr. Kearney's alleged torts. With respect to sharing non-public information, and as discussed above, the only alleged non-public confidential information shared was 1, Reed's April 12th, 2023 discovery motion, which had non-public documents attached to it. See paragraph 28. 2, statements about the Alberts grand jury testimony, paragraph 49. 3, a statement that feds have been involved longer than anyone is likely guessing, paragraph 50. 4, an audio file of Ms. McCabe's 911 call, paragraph 51. And 5, the denial of Ms. McCabe's ex parte harassment prevention order, paragraph 58. All 3 aiding and abetting counts are based on the theory that sharing these pieces of non-public confidential information helped Mr. Kearney spread the alleged false statements that plaintiffs killed Mr. O'Keefe and then sought to cover it up. The complaint does not allege, however, how sharing such information provided any assistance to Mr. Kearney to lie about the plaintiffs. Other than the April 12th, 2023 discovery motion, none of these alleged sources of confidential information stated or implied that plaintiffs were responsible for John O'Keefe's death, and thus did not support or encourage Mr. Kearney's allegedly defamatory statements that plaintiff killed Mr. O'Keefe and covered up. They're kind of saying here, you're on your own, kid. Like, it's the stuff that Karen Reed gave you didn't imply, other than that motion, that they did it. While the discovery motion did name Brian and Colin Albert as responsible for Mr. O'Keefe's death and Ms. McCabe for covering it up, Ms. Reed is absolutely immune under the litigation privilege for statements made in the motion. Dismissing, and here's a case from 2022 from California, dismissing aiding and abetting claims premised on statements and conduct protected under litigation privilege. There you go. Seems on point. For the same reason, the allegation that Ms. Reed funneled false statements to Mr. Kearney does not support the civil conspiracy claim. The complaint's only allegation that Ms. Reed funneled false statements to Mr. Kearney was sharing the publicly filed discovery motion. But Ms. Reed is immune from claims premised on her privileged statements made in the motion. Counts 5 and 9, IIED and NIED. Counts 5 and 9 assert claims for intentional and negligent infliction of emotional distress, respectively. Both claims are based on Ms. Reed's alleged campaign of outrageous and false statements. The claims are thus based on Ms. Reed's allegedly false statements. However, defamatory statements cannot, as a matter of law, satisfy the extreme and outrageous conduct requirement of the IIED claim, citing a Massachusetts case from 2017. Moreover, even if plaintiffs could maintain emotional distress claims based on defamatory statements, because the defamation claims based on those statements fail in this case, the emotional distress claims should also fail. Citing a First Circuit case from 2008, holding that claim based on false statements cannot be brought in the guise of an intentional infliction claim, which would divorce it from the well-developed law of defamation with its attendant privileges and defenses. Seems on point. What is the judge going to do? Your guess is as good as mine. In particular, the statements Ms. Reed made to the police in June of 2022 and in the April 12th, 2023 discovery motion are protected by the litigation privilege. A privilege which protected an individual from liability for defamation would be of little value if the individual were subject to liability under a different theory of tort, right? Because they're not defamatory, as protected by the litigation privilege, you can't then use those same statements that are protected to say that they caused you emotional distress. See how that works? Similarly, the statements referred to in paragraphs 49, 50, 51, and 58 about the Alberts' testimony to a grand jury, the Fed's involvement, a voicemail excerpt containing Ms. McCabe's 911 call, and the denial of Ms. McCabe's ex parte HPO do not injure the Alberts' reputation and thus cannot constitute extreme and outrageous conduct for purposes of an IIED claim. Similarly, because these statements are not injurious to plaintiff's reputation, no reasonable person would have suffered emotional distress as required for an NIED claim. Likewise, the statements of Facebook posters and attorney Alan Jackson in paragraph 75 and 115 cannot constitute IIED, which requires that, quote, the actor intended to inflict emotional damages or that he knew or should have known that emotional distress was like the result of his conduct. Emphasis added. They also cannot underlie an NIED claim, which requires that the claimed harm result from Ms. Reed's alleged negligent conduct, not the alleged defamatory statements of third parties, right? She's not responsible for what random people on the internet post. She's not responsible for things that Alan Jackson says. Finally, the statement made to the Rotten Mango podcast that someone in that house killed John O'Keefe does not support emotional distress claims because, as argued above, the statement does not identify a particular individual and thus are not defamatory as to any of them. Footnote 10, which reads, Count 4, the IIED count, also seems to base the claim on the allegation that Ms. Reed hired a private investigator previously associated with Harvey Weinstein. That conduct cannot be the basis for an IIED claim for two reasons. First, hiring a private investigator to interview potential witnesses is protected by the absolute litigation privilege. Second, and there's a case here on point, Illinois case from 2023 affirming dismissal of IIED claim based on hiring private investigator. Second, the mere act of hiring a private investigator does not amount to extreme and outrageous conduct, especially where the complaint does not allege the investigator engaged in harassment or other improper behavior. Here, the complaint only alleges that the private investigator attempted to interview plaintiff Higgins once and was rebuffed. He was like, yeah, no, talk to the hand. I don't want to talk to you. There is no allegation of an invasion of privacy, no allegation of illegal conduct, and no allegation that Higgins suffered any negative effects from refusing to speak to the private investigator. Given that Higgins is a law enforcement officer, presumably used to hostile interviews, the mere attempt to talk to him is not conduct so outrageous in character and so extreme in degree as to go beyond all possible bounds of decency and to be regarded as atrocious and utterly intolerable in a civilized community. Conclusion. Why are they pointing all of that out? Because those are the things you need to prove in order to succeed on an intentional or negligent infliction of emotional distress claim. For the foregoing reasons, defendant Karen Reed respectfully requests that the court allow her motion to dismiss and she be awarded her reasonable attorney's fees and costs. XOXO, Karen Reed, by her attorneys, Damon Seligson, Chaz Waters, Aaron Rosenberg, dated June 23rd, 2026. Why are we just getting this now, today, on July 9th? Because in Massachusetts, they have this weird thing where everyone has to, the motion is served on the other side, not filed with the court, and then the other side opposes, and then maybe there's a reply, and then once all the papers are ready and collected, the entire thing gets filed with the court. Okay? Go to the chat for a minute, and right after that, we're going to look to Karen Reed's affidavit. Thank you, Ms. D. Bates. So appreciate you having done away with the McCabe's and Albert's BS. Your number one UK fan. Oh, thank you so much, Ms. D. Bates, for tuning in from across the pond. A desire for civil discourse says, what was in the duffel bag? Probably not Chloe. Pretty sure what's her name took Chloe when she collected Colin. Or if you believe it, Chloe has now been renamed Cora and was previously named Cassidy and was examined by Dr. James Crosby in Vermont. We went over that the other day. It was interesting, to say the least. I know now why they didn't call James Crosby, and so do you. I'm the problem, it's me, says, dumb question, Melanie. Nothing is like TV, but can Karen sit in on the depositions? Yes, she can. She's a party. She's allowed to sit in, of course. It's not a stupid question at all. A lot of people wouldn't know that, but as a party, you have the right to sit there while every single witness is being questioned. And clients often do, and she absolutely will. If Brian Higgins is being deposed today, as some of you say is actually happening, I'm pretty sure Karen Reed is sitting right there at the table so she can look him right in the face. Thank you, Barry Raven, for being here from Ireland. Sláinte, my friend, for 29 months. Lorelai is opining that she thinks a backboard was in Higgins' bag so that they would be able to transport John O'Keefe. Plain Jane opines that they just wanted her prosecuted and convicted and forgot she has rights. They caused their own distress. Heather wants to know how Nicole feels about her husband letting his friends listen to their intimate moments at 2:22 a.m. Clumper-like opines that Chloe left with Caitlin and was seen in her garden by a neighbor. All right, everybody smash the like button. Northern Ireland is in the chat. Karen is here. Yeah, Lieber Robin says hiring an investigator is legal. Higgins seems pretty soft if that inflicted emotional harm. Yeah, can you imagine that he's going to have to testify today in order to prove his case? That, except he's being deposed in the wrongful death case. Will they ask him about whether an investigator came to visit him and whether that scared him and he was intimidated and sleeping with the lights on and a shotgun under his pillow? I mean, well, he's ATF, right? So dealing with hostility isn't their specialty, but he was ATF, right? Scott? Is he still? Do we know? Maybe you're talking about something else. Custer Crazy Horse says their hatred for Karen outweighs their hunger for justice for John. Pretty sad to watch. I mean, do you think they filed this lawsuit because they think that this is what an innocent person would do? I mean, maybe. Jay Doe says, since it's Massachusetts, I'm surprised they didn't accuse Karen of being a witch. They remind me of Monty Python logic and Monty Python and the Holy Grail. Well, here's the funny thing, Jay Doe. I guess you weren't here because I did a whole show on, when after Judge Gilday said that we don't want courts should not be a spectacle. Did a little research into the Salem witch trials from 1692. And courts have been a spectacle in Massachusetts since 1692. In fact, this is really interesting if you didn't know. 200 people were accused of witchcraft. 30 of them were convicted very quickly in Salem, Massachusetts. And 19 of them were executed. They were hanged at a place called Proctor's Ledge. That is, I got to take this call. Hold on one second. Oh, thank you for excusing me for a moment. It's hard to, do normal life things and also be on YouTube all day long because sometimes you just got to take a break and you got to take the call. Otherwise, you're never going to reach the person again or the doctor's office because, nobody likes to answer the phone nowadays. Good luck getting through. Okay, here we go. Yes. So we did do a whole thing on the Salem witch trials. And then also somebody in the chat made this really cool graphic about Proctor's Ledge because you just can't make it up, right? So I'll show it to you because it reminds me that it's pretty cool. Isn't it ironic? Don't you think? Here it is. Proctor's Ledge is interpreted by a very, very creative viewer. Oh, sometimes you gotta laugh, or if you're not looking at your screen, it is actually Michael Proctor walking on a giant cell phone off a cliff. Thank you, Jay Doe, for reminding us. Sometimes we gotta laugh. Monty Python is hilarious. I agree. Back to the papers. Crazy Mary says, I come here for the musical references. Thanks. I think in song lyrics. It shows. Here you go. This is the affidavit of Karen Reed in support of her motion to dismiss due to the anti-SLAPP statute. And this is things that Karen Reed is actually swearing to under oath. So many people will be happy because they say Karen Reed has never testified under oath. And well, she does have a Fifth Amendment right against self-incrimination and the right not to testify in a criminal proceeding and the right that is not held against her. But, there's a lot of trolls on the internet who think that she should, I don't know what they think. They you can't fix stupid. You can't fix stupid. She also did sit for a deposition for a full day. I guess they're trying to schedule day 2. I think it was around the 24th or so of June, I think, right? We heard that in court. All right, here's the affidavit of Karen Reed. I, Karen Reed, on my oath, hereby do declare and attest as follows. I am over the 18 years of age. I submit this affidavit on personal knowledge in support of my special motion to dismiss. I was acquitted by a jury of all criminal charges relating to the death of John O'Keefe III after a full and public trial that exposed pervasive investigative misconduct and corruption. I did not cause and am not responsible for Mr. O'Keefe's death. Okay, I'm going to say that a little louder for the people in the back. Karen Reed is swearing, I did not cause and I'm not responsible for Mr. O'Keefe's death. There it is. I did not strike Mr. O'Keefe with my car. I dropped Mr. O'Keefe off at 34 Fairview Road in Canton, Massachusetts. And contrary to what the Commonwealth claimed in my criminal trial and what the defendants now assert, Mr. O'Keefe and I did not have an altercation before I dropped him off at the Alberts house. He did not have any injuries when I dropped him off. Additionally, a Ford Edge was not present when I dropped off Mr. O'Keefe. Prior to my arraignment, I stated to the investigating officers that Brian and Colin Albert beat up Mr. O'Keefe. My statement to the investigating officers was released to the public during a judicial hearing in April of 2024. During the Commonwealth's prosecution of me, I stated in a discovery motion that Brian and Colin Albert were responsible for Mr. O'Keefe's death and that Ms. McCabe was the mastermind who covered it up. That's it. She said it in a motion. This statement was not motivated by any commercial objectives. Rather, when I shared the motion with Mr. Kearney, I hoped he would publicize it so that the public at large would understand that I had been framed. And in order to pressure the Commonwealth to drop its prosecution of me and instead prosecute the true perpetrators. Worked. I mean, the persecution of the true perpetrator part didn't work. But you did receive a lot of public support because we read the papers. We watched 2 trials. We read every single police report and investigative report that we could get our hands on. And we came to our own conclusion and conclusions based on the behavior of these same people involved in this lawsuit as plaintiffs. My statements to reporters that Ms. McCabe had perjured herself during her trial testimony in my second trial were made on the courthouse steps immediately after the conclusion of that day's proceedings. At trial that day, Ms. McCabe had admitted to lying to FBI agents in the spring of 2023. She misidentified herself and she lied about whom she called while agents were waiting outside her house. And that is true. She did lie. And she admitted that she lied. And all of this happened. Jennifer McCabe lied to the FBI before Aidan Kearney ever published his first article about this case. Jennifer McCabe said it wasn't really a big deal. It was like the ice cream truck coming to the neighborhood. Ice cream truck. The purpose of making such statements to reporters outside court was to widely disseminate to the public my belief that the McCabes, the Alberts, and Higgins were responsible for Mr. O'Keefe's death, which formed a significant portion of my criminal defense. The goal was to galvanize public support and to put pressure on the Norfolk County District Attorney's Office to drop the prosecution or to refrain from a second retrial in the case of another mistrial. This same belief is the subject of my pending civil litigation against the plaintiffs and others. On January 12th, 2026, I appeared on a podcast called Rotten Mango, which has in excess of 6 million subscribers on YouTube. My statements on the Rotten Mango podcast that Mr. O'Keefe entered the Alberts' house, that he was severely injured in the house, and that someone within killed him related to the pending wrongful death lawsuit filed against me in Plymouth Superior Court by Mr. O'Keefe's estate and his family members, in which I have made the exact same allegations and pleadings and under oath, and they were intended to support my defense. These statements in my pleadings and sworn testimony in the wrongful death action and echoed in my public statements were intended to persuade any judge or fact finder I should not be held liable for Mr. O'Keefe's death. My statements were also intended to convince the O'Keefe family that it had sued the wrong party and should drop its suit. XOXO, signed under the pains and penalties of perjury on June 18th, 2026, Karen Reed. There it is, a little bit louder for people in the back. I did not cause and I'm not responsible for Mr. O'Keefe's death. I did not strike Mr. O'Keefe with my car. Ford Edge wasn't present. I didn't have a fight with him before I dropped him off. Everything I said was said to pressure the Commonwealth to drop its prosecution of me and instead prosecute the proper perpetrators and to galvanize public support. And if you think, any of you in the chat think that anything that was alleged in the complaint of Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert is defamation under the law and not protected speech under anti-SLAPP, if you think there's anything that could possibly slip through, please let me know in the comments or in the chat what you think, because I'm curious to know. Fairy Raven says, Jen called Nicole at 4:30 a.m. to find out if John was at Fairview. So that means Nicole and probably Brian were awake long before John was found. I just learned that from the Voss interview now. I don't know that the time was 4:30 a.m. Fairy Raven. I think it was closer to 5, but I don't exactly remember. I think in the papers they said it was 5:07 after she heard from, because Jen calling Nicole at 4:30 a.m. would be before Karen called Jen. So I think it was after. I think it was 5:07, but yes, I see your point. Thank you, Fairy Raven. Slancha. Vicky Andrews says, just because I care about our group, y'all be safe. Love from Texas. Aw, thanks for your 20, sweetie. Nana Bear says, I live in Salem. They hung 13 innocent people and have made money off of it for 300 years. Thank you, Nana Bear. It must be pretty annoying to live there around Halloween. Must get real crowded. Foxy Wolf says, haha, I would love to see them try and sue AJ for defamation. They think they have problems now. Oh, please. Somebody is saying she doesn't think Higgins killed him, only Brian and Colin. And then the response, thanks, Babs. And then the response to that, Speedy. And Turbo's mom says, I don't think she knew about Colin yet at that point. Right. And they're talking about her statement on body cam where she says, John, we're all in on the same joke, right? John was pulverized and my taillight was cracked. Colin Albert and Brian Albert beat him up. Yeah, she I don't think she ever publicly said anything about Higgins. She always said Brian Albert and Colin Albert, right? Allie says, no matter the time. I bet you anything they were not asleep. Edward Scott says lots of evidence in this case was tampered with, even the electronic evidence. I wouldn't trust anything that came from the MSP or the DA's office. And GRN says, I can't like this enough. I mean, I think these are really good arguments. I think that everything she said or told Aidan Kearney or sent to Aidan Kearney is all protected under litigation privilege. And if that's true, they can't show defamation. They can't show intentional infliction of emotional distress because it doesn't rise to the level. And in any event, if it's protected by litigation privilege, they can't use it anyway. New order for Proctor's attorney from Gilday, says Kelly. All right, hang on 1 second. We're going to move on to the Haas defendant's response to this. Let me close some windows here for a minute. There's a lot of windows open here. I'm getting a draft. If you missed this before, this is a really good quote from Adam Smith. Let me put this up here for a second so you can all admire it. I'll read it to you. Showing mercy to the guilty can become cruelty to the innocent because justice loses its balance when wrongdoings go unpunished. Dun, dun, dun. Let's look amongst yourselves for a second. I don't want to waste time looking for this. So if it came out yesterday, we've already seen it. There was an order where the judge wanted Karen to submit Word versions of her motions for some reason. And right now my inbox is too clogged up, but it looks like Aidan's motion has dropped, which we will do in a separate show. So I don't know anything about an order for Proctor's attorney. I don't see it in my inbox. And if it is in my inbox, it's not properly labeled in the subject line. So I can't find it quickly. And so if it pops up, of course, I will share it with you. Thanks, Kelly. But right now, what we got to do is look at the opposition of Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins. They only have an hour and a half for the stipulation regarding keeping protected information confidential. Thank you, Carrie Bishop. Yeah, it was due by what, 4 p.m. today or something, 3 p.m.? I don't know. Will it hit the docket right away? Not so much. Okay. Lola, the good dog, is here and says John O'Keefe was not hit by a car. Car did not hit John O'Keefe. Thanks, V5. Jado says, do you think Brian Albert threatened people at the house with being accessories if they talked? I have no idea. I have no idea what he did. I wasn't there. I know that he's, people have said that he's a scary guy. You saw him sitting in court, staring at the jury during trial number 1, closing arguments. And there's a lot of information out there about his prior acts and such. It could be that whatever happened outside the house and he never went inside the house and it happened in the backyard. Maybe he went there to take a leak. I don't know what happened. And I certainly won't speculate about anything that Brian Albert did. I don't know if that was a rhetorical question, but you can draw your own opinions and conclusions from that one. Okay. Next. The judge ruling in your inbox is the judge's order regarding the Word document thing. So we covered that yesterday, right, Tiff? Tiff, you're always here. Is it the same one that we covered yesterday? Oh, okay. No, this is good. Hold on. All right. Let me just hold on. This is in this case, actually. So yesterday the judge wanted Karen Reed to provide word versions of her motion, and I have no idea why. This order came out just now. Thank you to Kelly for sending it to me. And this is in this defamation case. Let me just pull it up for you. Let's go here. Not everybody can or will jump to breaking news for you guys. You know that. But it's only because I love you. Guess how much I love you? One of the greatest children's books ever written, in my opinion. All right, here we go. This order just dropped just a little minute ago in the Jennifer McCabe versus Karen Reed et al. Case. So it's the defamation case. Order. Attorney Seligson provided a response to my July 8th, 2026 order. Right. Yesterday, the judge asked not only for them to provide word copies of Karen's motions, like word versions, but also he asked some questions like, was there a response to this email at this time? And was there a response oral or in writing? And you need to tell me. So apparently Attorney Seligson did tell him, and he said, Attorney Seligson provided a response to my July 8th, 2026 order. The response identifies a June 26, 2026, 12:31 p.m. email from Attorney Rosenberg to Attorney Murphy. I think Attorney Murphy is so just for words because he's still using Windows 98. I know, it's bizarre. Attorney Murphy is ordered to email to the Plymouth Superior Filings Department before 4:30 p.m. today. Okay, so you got 2 hours. An affidavit setting forth the reason such email was not included in Exhibit B to his declaration of July 7th of 2026. I mean, Kieran Murphy, right? And Kieran Murphy represents the Haas. He's one of the attorneys representing Jennifer McCabe, Brian Albert, Brian McCabe. I mean, Jennifer, Brian McCabe. There's too many Brian. Jennifer McCabe, Brian Albert, Brian Higgins, Colin Albert. So that's what it's really weird that a judge would issue orders asking for other stuff when he's reading and deciding on motions, because like if it's not included, then the judge would just disregard it. So it's not Proctor's attorney. It is because this is in the Jennifer McCabe versus, this is in the defamation case. See? Not the wrongful death case. I don't know what somebody who's got more time on their hands than I do can try and figure out what this is all about. But right now I don't have the bandwidth for it because also I'm talking about something different right now. But I'm sure it has to do with this motion that we're talking about. Okay. Moving on. Isn't that the little boy who sat with the House plaintiffs in court? I don't know. Proctor's attorney is Hamill, and Proctor's attorney is representing him in the other case, the car accident case that didn't happen. Okay, here we go. This is the plaintiff's opposition to defending Karen Reed's special motion. So remember, this is only Karen Reed, not Aidan Kearney yet. That's going to be on a different show. Because too much of this at one time is too much of this at one time, right? Let's hear what they've got to say for themselves. Everyone smash the like button, please, because it is the kind thing to do. And if you're just joining, welcome. Okay. Oh, let me get my highlighter ready, willing, and able. Defendant Karen Reed's motion to dismiss should be denied at the threshold because it is not directed to the operative complaint. Plaintiffs Jennifer McCabe, Brian McCabe, Colin Albert, and Brian Higgins filed the first amended complaint on June 5th, 2026, adding detailed allegations concerning Reed's defamatory statements and conduct, including statements Reed personally made during recorded interviews with Terry Dunn-Muir and her production team. Reed's motion, nevertheless, is directed to the inoperative superseding pleading. It uses the former Barnstable captain. Wait, what? It uses the former Barnstable caption, cites obsolete paragraphs and count numbers, and fails entirely to address the AC's new allegations. The amended complaint's new allegations. Contrary to Reed's anticipated position on this issue, that defect is not cosmetic. Okay. How did I miss that? The wrong caption was on there. Hold on now. And how could they refer back to the original complaint and not the amended complaint? That's a problem if they did. Hold on. It says it's in Plymouth. What are you talking about? Wait a minute. I'm looking at her motion to dismiss right here. It says Plymouth, has the right caption. So maybe there was a cover page to this that had Barnstable on it. I don't know. Let's keep going. Contrary to Reed's anticipated position on this issue, that defect is not cosmetic. Reed's procedural and substantive misfire matters because the Muir allegations, wherein Reed accused plaintiffs of being first-degree murderers and participants in Officer John O'Keefe's killing, are now central to plaintiff's direct defamation claim against her and to plaintiff's theory that Reed knowingly participated in a coordinated campaign to destroy plaintiff's reputations. Yeah, I mean, that is the complaint that took us 4 hours or 4 shows to get through, right? I think so. A motion that ignores the operative pleading cannot carry Reed's burden under either Rule 12b-6 or the anti-SLAPP statute. On the merits, the amended complaint alleges a straightforward and deeply damaging course of misconduct. Plaintiffs allege that Reed struck O'Keefe with the back of her Lexus SUV while intoxicated, made repeated admissions at the scene that she had hit him, and later abandoned those admissions in favor of a public relations strategy that falsely blamed the plaintiffs for O'Keefe's death. Plaintiffs further allege that Reed enlisted defendant Aidan Kearney as a public mouthpiece, used intermediaries, counsel, and encrypted communications to feed him non-public information and defamatory narratives, praised his publications, coordinated with him around court proceedings and media events, and celebrated the resulting damage to plaintiffs' reputations and to her own jury pool, citing the amended complaints paragraphs cited here. The result, as pleaded, was not constitutionally protected petitioning. It was a multi-year campaign of defamation, harassment, intimidation, and destruction aimed at witnesses in Reed's criminal case and sustained for profit, publicity, and litigation advantage. For the following reasons, Reed's motion must be denied. Background. Procedural history. Plaintiffs commenced this action on April 16th, 2026 in Barnstable County Superior Court, alleging that Reed and Kearney orchestrated a multi-year campaign to defame, harass, and torment the plaintiffs by falsely asserting that they were responsible for Mr. O'Keefe's death. And a cover-up. after the case was transferred to Plymouth Superior Court on May 27th, 2026. Plaintiffs filed and served the operative amended complaint on June 5th of 2026, which they are allowed to do once as a matter of right. The amended complaint amended the initial complaint in numerous material ways. Yet on June 18th of 2026, Reed served a purported special motion to dismiss and Rule 12b-6 motion directed not to that operative pleading, but to the superseded complaint. The motion failed entirely to respond to a series of new allegations made against Reed, used the old case caption, and referenced non-operative count numbers and citations. See declaration of Kieran Murphy in support of his opposition. Okay, so that's what the judge is looking for, something attached to Murphy's declaration that he didn't attach. Only after plaintiffs inquired of Reed's counsel about Reed's failure to respond to the amended complaint did Reed serve a revised motion on June 23rd, 2026, captioned in Plymouth County and keyed to the amended complaint's paragraph and count numbers. Okay, so the one that, oh man, you're going to make me do the work on this? All right, so the one that we just looked at is dated June 23rd of 2026. So it is the correct one. All right, so what are you whining about? The one that we just read is the proper one, because that one is dated June 23rd, 2026. That belated filing did not cure the Rule 9a defect. It merely preserved the same substantive attack while swapping in new citations. Reed's June 23rd motion was untimely under Rule 9a. Plaintiffs never consented to its service, and plaintiffs put Reed's counsel on notice that their inclusion of the June 23 motion in the instant package would violate Rule 9a. See Murphy Declaration, Exhibit B. Footnote 1, which says, moreover, Reed never initiated a Rule 9c conference prior to filing this motion package. Rule 9c is meet and confer, meaning we're going to meet and try and work it out instead of bothering the judge. Reed should not be permitted to deflect the court's attention from the massive procedural and substantive deficiencies that she answered the wrong pleading by reserving after the deadline a cosmetically corrected motion that merely changes citations and count references. He's saying you didn't follow the rules, so the court shouldn't even read it. And they're saying that on June 18th, she filed the motion to dismiss. 5 days later, she corrected it, which is the one that we just read. And he's saying it's outside the time limit. And so the court should disregard. And that is what apparently the court wants clarification on in the latest order that we just read. Factual allegations. Plaintiffs were key witnesses in connection with the Commonwealth's investigation into O'Keefe's death and Reed's prosecution. Well, you can't have both ways. You can't have it both ways, right? You can't say we didn't see anything, and why is everyone harassing us? Because we're just doing what we're supposed to do as good citizens, and we want to testify and start a whole organization around the word testify, and then you don't want to testify, and then say we're key witnesses. Key witnesses to what? Tell them the guy never went in the house. This is not the same attorney that used AI. That was Proctor's attorney in a different case. This is the Haas defendant's attorney. And 18-Wheeler says, strange that none of the witnesses saw anything. The amended complaint alleges that on January 29th, 2022, Reed struck O'Keefe with the back of her Lexus SUV while driving drunk, left him incapacitated in freezing conditions on the front lawn of 34 Fairview Road in Canton, and repeatedly told first responders, I hit him, I hit him, I hit him. Reed Reed was later indicted for second-degree murder, manslaughter while operating under the influence, and leaving the scene of an accident resulting in death. After a mistrial in 2024, she was retried in 2025, convicted of operating under the influence and acquitted of the remaining charges. We know, we were there. Plaintiffs allege that Reed initially confessed that she was responsible for O'Keefe's death, but later changed course and began falsely accusing others. According to the amended complaint, before her June 2022 arraignment, Reed falsely claimed that O'Keefe had been beaten up by Brian and Colin Albert, even though she knew that accusation was false because she knew she had hit O'Keefe with her vehicle. Well, she just signed an affidavit saying she didn't hit him with her vehicle. Well, we'll see. Let's keep going. Plaintiffs further allege that Reed later enlisted Kearney to disseminate and amplify a false narrative that plaintiffs murdered O'Keefe, covered up the murder, and framed Reed. Reed used an intermediary and counsel to conceal her relationship with Kearney and preserve plausible deniability while feeding Kearney non-public information and lies to publish on her behalf. The amended complaint describes the public launch of the defamation campaign in April 2023 when Reed filed a discovery motion falsely accusing Brian Albert and Colin Albert of responsibility for O'Keefe's death and McCabe of being the mastermind of a cover-up. Reed attached an unredacted incident report containing plaintiffs' private addresses, cell phone numbers, and social security numbers, and forwarded the filing to Kearney through an intermediary so he could publish the accusations and foment harassment. Kearney's defamatory Canton cover-up posts followed, and the coordination continued throughout 2023, including in-person meetings, encrypted communications, and over 189 phone calls between Reed and Kearney. Can't wait to see the communications between the Haas defendants, or Haas plaintiffs in this case, and Michael Proctor. They have moved for a protective order so that all that stuff will be private. And so far it's been granted because, they're on a worldwide privacy tour. In Kearney's initial post, he stated that Brian Albert and Colin Albert were capable of killing O'Keefe, that Colin Albert had motive, that McCabe was the quarterback of the cover-up, and that McCabe could not have covered up the murder without law enforcement assistance, citing paragraphs in the amended complaint. Kearney claimed there was a mountain of evidence that O'Keefe was killed by Brian Albert, Colin Albert, and possibly others, and that those statements were based on sources that were, in reality, Reed and her legal team. Thereafter, Kearney's audience exploded, giving Reed a larger platform for her defamatory narrative. Kearney used phone numbers made public through Reed's filing, which he received from Reed, to call McCabe and Brian Albert during a broadcast and accuse them of a cover-up, and he left Brian Albert a voicemail asking whether Brian Albert or Colin Albert killed O'Keefe and whether Brian Albert was covering for Colin. Kearney also displayed the incident report containing plaintiffs' personal identifying information, after which plaintiffs began experiencing disturbing levels of harassment. Minutes after that broadcast, Reed's attorney, David Yannetti, congratulated Kearney by text, writing that it was a great effing show. The coordination continued during 2023. On April 23rd, 2023, Reed falsely told Kearney through an intermediary that certain witnesses had testified to a grand jury that Colin Albert was present at 34 Fairview after O'Keefe arrived, while also stating that she could not send grand jury testimony because it was sealed. That same day, Reed told Kearney that the feds have been involved longer than anyone is likely guessing, even though the federal investigation into O'Keefe's death was not public information. I'm just going to point out that we still don't know what the federal investigation was about, but that they did do an accident reconstruction of the car accident that didn't happen. In December of 2023, Kearney published audio recovered from O'Keefe's phone that only the Commonwealth, Reed, and Reed's legal team possessed at the time. Reed and Kearney later communicated directly, including through Signal, and exchange. Okay, big deal. And exchange. Who like WhatsApp? Michael Proctor. Reed and her lawyers also met with Kearney in person to coordinate extrajudicial publications with Reed's litigation and media strategy. After a May 3rd, 2023 meeting with Reed and her counsel, Kearney published a video stating that O'Keefe was murdered by Brian Albert Colin Albert, the dog, and every other single person in that house, which included McCabe and Higgins. Kearney later accused McCabe and Brian Albert of involvement in cover-up, called the McCabes evil, and asserted that millions of people knew they had participated in O'Keefe's murder and cover-up. Reed's counsel then appeared on courthouse steps and stated that Brian Albert, McCabe, and everyone else in the house had some level of involvement. Reed continuously expressed her approval of the reputational damage caused by Kearney's publications. On September 29, 2023, Reed messaged Kearney, "Look at what you've done to their reputations and to my jury pool." Italicized and bolded for emphasis. Chris Albert's business is the next casualty. Important to point out, Chris Albert is not a plaintiff in this lawsuit. Around the same time, Reed and Kearney became administrators of a Facebook group that became a forum for defamatory and harassing posts about the plaintiffs, and Reed posted confidential criminal case information there. Was this a public Facebook group or a private Facebook group? I don't know. I don't do Facebook, so tell me. Oh, please. The amended complaint also alleges that Reed made egregious defamatory statements during interviews with documentarian Terry Dunn Muir. Yeah, she did the Body in the Snow, I think. During her first criminal trial, Reed authorized Muir to record her trial preparation, including interviews with Reed, her attorneys, and her family, as well as conversations among Reed and her counsel. On April 12, 2024, in Reed's presence, her attorney, Alan Jackson, verified to Muir and production assistants that Reed had told police Brian Albert, Colin Albert beat up John. My taillight was cracked when John was pulverized. Oh, there it is. There's the quote. And Reed did not deny having made those statements. Right. And they're protected under the anti-SLAPP statute because these statements were made to defend herself against the false allegations of second-degree murder. How do you get around that? Let's see if they get to that ever. They just are, unless they just want to keep putting this stuff out into the public. But how do you get around that? On or about April 30th, 2024, Reed told Moorer that McCabe got herself into a bad mess that night, and she helped clean it up. That McCabe knew that John was dying, and she helped expedite it, and that Ms. McCabe was a first-degree murderer. Emphasis added. In the same interview, Reed stated that plaintiffs were being federally investigated, that, quote, they know they killed John, and that she could not have sympathy for the witnesses because they're murderers. Okay, this was during the first trial. And I'm going to point out again, Karen's defense is all of these statements were made to defend herself from the charges, to try and point out to the public and the Commonwealth that they should drop their case against her and or decline to retry her in the case of a mistrial. And after April 30th, 2024, there was a mistrial. Remember? I know you do. On June 15th, 2024, Reed told Muir that Higgins, Brian Albert, and Colin Albert had motives to kill O'Keefe and suggested that O'Keefe could have been struck during an escalation altercation inside 34 Fairview. Right. Did we the mistrial happened after that date as well, right? June 15th, after June 15th? Because I know that her acquittal was June 18th of 25. And I think that the mistrial was in July 2024. On June 22nd, 2024, Reed stated that she knew Higgins had a role in helping kill O'Keefe, helping him get into the snow and helping frame Reed, while also stating that Brian Albert and Colin Albert would have enjoyed roughing John up. When Muir raised the possibility that Reed could be sued for making such strong statements about Colin Albert, Reed responded that if Colin could prove she was lying and that the statements were defamatory, he could sue her. Okay. That still doesn't make what she said not protected by the anti-SLAPP statute. Plaintiffs allege that Reed made those statements knowing they were false and knowing plaintiffs had nothing to do with O'Keefe's death. Reed's defamatory statements did not stop there. During her 2025 retrial, Reed told reporters that Ms. McCabe's testimony was, quote, another instance of perjury, and that Ms. McCabe was lying. Reed knew those statements were false. During the retrial, the prosecution presented footage in which Reed acknowledged the possibility that she had run over or clipped O'Keefe and that she might have some culpability as a result. That was one of those interviews where she said, I don't know, could I have clipped him or something like that? That she was, rethinking the next day or something, what could have happened. Reed later stated that O'Keefe entered 34 Fairview and met his demise, and that someone in that house killed John O'Keefe, referring to the plaintiffs. Well, someone in that house could refer to, as they pointed out, anyone who was in that house, and there were a lot more people in that house than the four of these plaintiffs. The harm to plaintiffs was severe and sustained every day since April 18th, 2023. That's the day of Aidan Kearney's first article. Plaintiffs and their families have been harassed and tormented because of Reed and Kearney's unlawful conspiracy. Well, your families aren't suing, so you have to point out what happened to you specifically, each of the four of you, which is why I have always said, and I'm going to continue to repeat, that I do not think all four of these people should be represented by the same lawyers. Plaintiffs have become prisoners in their own communities, besieged by people who accepted Reed's and Kearney's lies that plaintiffs are murderers. Plaintiffs have faced physical confrontations and harassment at their homes, businesses, and children's activities, sustained a barrage of online abuse, and were harassed while appearing in court as witnesses. The harassment became so extreme that the criminal trial judge ordered a courthouse buffer zone while Kearney and his followers chanted "cop killers" as plaintiffs walked by. Remind me, chat, because I might be misremembering. But is the reason that Judge Kearney agreed to a buffer zone because of these people? Because of Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert? Because I don't know how many days they were in court other than the days they testified, but I don't seem to think that that was the reason for the buffer zone. And this is a little bit of a me. And that's what it says. The harassment became so extreme that the criminal trial judge ordered a courthouse buffer zone while Kearney and his followers chanted "cop killers" as plaintiffs walked by. The amended complaint's claims rest on allegations that Reed directly and through Kearney falsely accused plaintiffs of murdering O'Keefe and participating in a conspiracy to murder him and cover up his death. Plaintiffs allege those statements were defamatory per se because they accused the plaintiffs of heinous criminal conduct and were made negligently, knowingly, or with reckless disregard for the truth. Reed's motion does not answer these allegations as pleaded in the amended complaint. The motion lists only a handful of Reed's statements from the earlier pleading and seeks dismissal based on count numbers and paragraph citations that do not match the amended complaint. Most significantly, although the amended complaint alleges for the first time Reed's direct statements to Murr in paragraphs 91 through 99, Reed's motion does not include those statements in its description of the defamatory statements at issue and does not argue why those allegations fail under Rule 12b-6 or the anti-SLAPP statute. That omission is a dispositive concession and confirms that the motions should be denied. So they're alleging that because she didn't specifically refute those claims, that they should automatically be allowed. I don't know why she didn't, but let's keep reading. Argument. Reed's special motion to dismiss must be denied under the anti-SLAPP statute. The anti-SLAPP special motion to dismiss is a strong medicine, offering powerful procedural protections. The statute is only to be employed in a limited context. Because of its limited nature, the SJC recently returned to the necessarily narrow and strict construction, requiring courts to proceed cautiously when considering anti-SLAPP motions to dismiss. And that's a 1998 case. Throughout its analysis, the court shall consider the pleadings and supporting and opposing affidavits stating the facts upon which the liability or defense is based. The standard of review is fundamentally different from a Rule 12 motion because it incorporates additional fact-finding beyond the facts alleged in the pleadings. For her special motion to dismiss to survive the first stage of the court's analysis, Reed must show that the challenged count has no substantial basis in conduct other than or in addition to her alleged petitioning activity. And I think she made a pretty good argument of that, saying that everything was designed to show that she was innocent. If she cannot make the requisite threshold showing, the special motion to dismiss is denied. If the threshold showing is made, the second stage of analysis follows. Citing more cases and more cases for their position. If the court reaches the second stage of analysis, plaintiffs must show that Reed's exercise of her right to petition was devoid of any reasonable factual support or any arguable basis in law and caused actual injury to the special motion opponent. Mixed claims based on proponents petitioning, along with substantial conduct other than or addition to the petitioning activities, inevitably involve an inquiry into both sides' legitimate petitioning rights. Thus, unless Reed can show that her activity was for the purpose of petitioning alone, which she cannot, I think she kind of did, the parsing of claims involving a mixture of petitioning and other matters is best addressed in the course of ordinary litigation, where both sides' claims and defenses can be fully analyzed based on a more complete record, not special motions to dismiss. Well, you should have a complete record before you bring a case like this, because you know about the anti-SLAPP statute and you know that cases can be dismissed on the papers for exactly the reason of preventing frivolous litigation. But I digress. Plaintiffs' claims against Reed are not based on petitioning activity alone. They're saying the amended complaint alleges extensive non-petitioning activity undertaken by Reed, including allegations that her motion fails to address at all. That non-petitioning activity, which Reed largely ignores, includes, but is not limited to, 1, defamatory statements to a documentarian, 2, a course of defamatory, harassing, and intimidating conduct that she jointly pursued with Kearney, 3, defamatory statements that McCabe committed perjury, and 4, defamatory statements that the plaintiffs murdered O'Keefe. Well, I think she did respond to all of those except number 1, which were the statements to the documentarian, because I don't remember her talking about Terry Moore at all. Zio? But I just read the papers, and I think that number 2 and number 3 and number 4 were all addressed. Some of this non-petitioning activity was criminal in nature. In post hoc fashion, Reed now offers a subjective, self-serving motive for her defamatory conduct that should not be considered by this court. Well, the self-serving motive is not going to jail for murder based on a car accident that did not happen. If you want to call that self-serving, by all means, every criminal defendant is entitled to the presumption of innocence until if and when proven guilty in a court of law, which she was not. She was acquitted. She's also entitled to defend herself against the wrongful death case brought by the O'Keefes for the car accident that didn't happen, which is petitioning activity. Thank you, JP. Section A. Happy birthday, Alicia. Happy birthday. She hopefully Keith gets business. I don't know who Keith is, but happy birthday, Alicia. This needs to stop. Reed failed to object to the operative complaint. Reed's motion incorrectly asserts that plaintiffs identify only a handful of allegedly false statements by Ms. Reed about the plaintiffs. Among many allegations that Reed ignores are the newly pleaded statements Reed made to Muir. Here's Microdots. Microdots, I heard you put out some really good new content lately. Everyone go subscribe to Drop Microdots if you're not. What are you doing? And also, Drop Microdots says if Jen's call log doesn't match her story, she's lying. Yeah, and a lot of deleted calls too, right? Deleted Google searches, deleted everything. Those allegations include direct accusations that McCabe is a first-degree murderer, that plaintiffs know they killed John, that plaintiffs are murderers and they know it, and that plaintiffs played a role in O'Keefe's death. Reed even asked Colin Albert to sue her if her actions were defamatory. I don't think she asked him to. I think she said he can if he wants to. Oh, and I had your cap on yesterday, so tell everyone where they can go buy the merch. I had your baseball cap on yesterday because I love that hat. It's a great hat. I'm sure that on Drop Microdot's YouTube channel, there's a link for merch, right? I think so, probably. There's over 8,000 of you here, so it'd be so cool if you would hit the like button and go on over to Richie, Drop Microdots, hit the like button too.
You're welcome.
Now for man had to pop in just for a minute. Reed even asked Colin to sue. Yeah, no, she didn't say, please sue me, please sue me. There's somebody else out there doing that, but not him. These are allegations central to the amended complaint. Every time I see AC, I just want to think air conditioning. These allegations are central to the AC and are ignored by Reed's motion. Yeah, she kind of needs to address that. Having failed to address the operative allegations, Reed has waived any request to dismiss the AC. If the first complaint is superseded, here's a case from 2005. The court is not required to dismiss the suit when a motion points to the weaknesses of the earlier pleading. Footnote 2 says, and Reed cannot raise new arguments through her reply. Citing a 1987 case where the court said, we need not pass on grounds raised for the first time in a reply brief. Oh. B, the amended complaint alleges that Reed engaged in non-petitioning activity and Reed fails to demonstrate otherwise. Memory says, she said it was all petitioning activity, so she did address it by saying all. They're saying she's just specifically did not address those particular statements that she made to the documentarian, but I say the same arguments could be made. Also, I do remember going over the amended complaint with you because I remember putting the initial complaint and the amended complaint side by side, and we went over every single thing that was different, every single thing that was new. We read all the new hyperlinks, all the new evidence that they wanted to show, they wanted to support their position. And we did the Lord's work. And you were there for all of it. Fundamentally, Reed's argument rests on the false premise that a criminal defendant may falsely accuse others of murder and surreptitiously conspire to do so with impunity by later arguing that it was all petitioning activity. Of course, Reed is incorrect. C, Burley, a case from 2009, reasoning defamatory statements made to members of the public and not intended to facilitate further consideration and response by the police do not constitute petitioning activity. Well, I would argue that Reed's statements were intended to facilitate further consideration and response by the police and or the DA's office. And so I think the case that you cited there flies in the face of your argument. Am I in the Twilight Zone? I could be. Do we have Twilight Zone emojis? Of course we do. For members. The case they cite from 2009 says defamatory statements made to members of public and not intended to facilitate further consideration and response by the police do not constitute petitioning activity. Isn't that exactly what she was doing? Call me crazy. And again, a 2017 case says that anti-SLAPP are limited to expressions in which a party seeks some redress from the government. She wanted the government to focus on the right people and drop her charges. I think she exactly explained that pretty well. 2005 case. Again, all of these cases fly in the face of what they're trying to argue. It says that the 2005 case holds that the anti-SLAPP statute does not protect tangential statements intended at most to influence public opinion in a general way unrelated to government involvement. No, it's not a general way. It is specific. These people did it. Focus on them. No investigation was ever done. I'm innocent. I did not hit my boyfriend with a car. No car hit John O'Keefe. She cites no authority for this proposition, which would overturn centuries of defamation law in this country. Well, here's the thing. I don't know when the anti-SLAPP statute was enacted, but it really wasn't that, it wasn't in existence centuries ago. It's all petitioning activity. And here's the centuries-old law that they cite. Imputation of a crime is defamatory per se, unless it's protected petitioning activity. She wanted, right? Her intention was to stop a sham persecution of the wrong person who happened to be her own self. Who's afraid of little old me? Well, you should be. You should be. You should be. Moreover, the AC expansively alleges that Reed pursued a course of conduct that did not seek redress from any governmental authority, but rather harassed, intimidated, and defamed private individuals in service of Reed's personal interests, right? There's no allegations that she told people that there's no evidence that she told people to go harass them. There are a lot of people out there who are nuts, okay? A lot of crazy people live on the internet. There's a lot of crazy people out there on Reddit and Twitter and other platforms. A lot of crazy people who do things of their own accord. Okay? Many people come to their own opinions and their own big boy and big girl decisions of things to do. And in no way would I ever condone anyone's harassment of these people, making phone calls, going to their house, picking on their kids, publishing that private information. I wouldn't never, ever condone any of that. But if you're trying to say that Karen Reed trying to defend herself by talking about what she thinks really happened was the reason that people were harassing you, I think it's a stretch. And you can tell me what you think. Simply put, Reed's years-long campaign to defame and intimidate witnesses. Oh, now she's intimidating witnesses? Because that's interesting because she hasn't been charged with that. Only Aidan Kearney has. In the prosecution against her, which included defamatory statements to a documentarian and others, her use of Kearney and others to launch defamatory attacks against the plaintiffs and her conspiracy to harass and intimidate the plaintiffs cannot constitute petitioning activity. Reed ignores the AC and wrongly claims that the plaintiffs allege only 6 instances of defamatory conduct, all of which she argues petitioning activity. In doing so, Reed not only fails to establish that those 6 allegations constitute petitioning activity, but completely fails to make the requisite threshold showing that count 1 relies exclusively on that conduct. Reed would have this court believe that count 1 is based solely on 1, Reed's initial false report to law enforcement that Brian and Colin Albert beat up O'Keefe. 2, Reed's false statements in a court filing, petitioning activity. 3, Reed's subsequent transmission of that filing to Kearney. 4, Reed's mischaracterization of grand jury testimony to Kearney. 5, Reed's extrajudicial statement that McCabe committed perjury. And 6, Reed's extrajudicial post-verdict statement during a podcast that the plaintiffs killed O'Keefe. Even a cursory review of the AC demonstrates that Reed's conduct extended far beyond these cherry-picked examples. In a recorded conversation with the documentarian, and they're going to repeat themselves again to make this longer, Reed stated McCabe was a first-degree murderer. Plaintiffs know they murdered O'Keefe, and the plaintiffs were murderers. Reed doesn't address these allegations at all. nor could she establish that these statements constitute petitioning activity where she made them to a documentarian with no expectation that the statements would be transmitted to a governmental body or released in a manner that could plausibly implicate a governmental proceeding. Well, yes, it was a documentary. They were filming a documentary. She knew it was going to be released to the public. And in the beginning, Terry Moore was a friendly. I think she was on Karen Reed's side. And then what had happened was all of a sudden she flipped, and it was very anti-Karen Reed. And that Body in the Snow documentary was very anti-Karen Reed in the end. But of course, she was talking to the documentarian who was going to publish this on the air. I forget what network it even aired on. Do you remember? Anybody know? And she was still trying to defend herself in between the trials. AC is amended complaint. I know, I keep thinking of air conditioning too. So when she made these statements, I argue, in 2024 to Terry Moore, was it HBO? It might have been GP. Yeah, HBO Max, yeah. Thank you. If you watched it, let me know if you liked it. I don't remember. There's been so many documentaries. There's been a Lifetime movie. There's been Dateline, Nightline. She was looking for public support. That would mean really that any criminal defendant who named a third party culprit could be sued for defamation. Think about it. Is Chris Melton going to sue Edric Foss for defamation? I don't think so. The difference is maybe Chris Melton was considered a suspect at one time. And unfortunately, because of the piss poor investigation by the Canton Police Department and the Massachusetts State Police, led by dishonorably discharged, disgraced, virulent, racist former trooper Michael Proctor, no other suspects were ever even considered. And so it was up to Karen Reed to tell her story to the public, because obviously law enforcement wasn't going to look into it. Snark Tank Cupcake. Oh, says it was my intro to the whole case. So I came in thinking she was likely guilty. Oh, the Body in the Snow show. What? Oh, tell us more. She says, so I came in thinking she was likely guilty. Then I watched the end of trial 2 with you and Emily D. Baker on recommendation from a New Hampshire friend and realized she was innocent. Praise be. Praise be. Under his eye. Oh, we got to put up the rubber duck. Hold on. We got to put up the rubber duck. Handmaid's Tale. Because it feels like we're in an episode of The Handmaid's Tale. Thanks to Jamie for making this rubber duck in a Handmaid's Tale costume, because this is like Salem. And I want to say, Snark Tank Cupcake, I love your, first of all, I love your username. And second of all, many people, including myself, when I first heard about this story, it was a little blurb on the news all the way back in January of 2022. Even here in New York, it was reported. And I think it was WBZ, but don't hold me to it, said that a woman, her car was impounded because there is ring camera footage of the incident that she hit her boyfriend with her car and left him to die in the snow. And I said, oh, that's terrible. That's terrible. And yeah, the antis love to point out that it was corrected. I don't know. How many years later was it corrected, first of all, that statement? Because there was no ring camera footage of the incident, because there was no car accident. But they got it out to the media. It was WBZ. And you know how the media works, right? Guess who picked it up? First thing, Daily Mail. It was worldwide in a day. And eventually they did retract it, but you can still find it out there. It was everywhere. And what do we know? They said, oh, I-Team sources say there's ring camera footage of the incident and the car has been impounded. And what do we know from the group text messages of these people? The news media was inside D&E Pizza, owned by Chris Albert, at some point. And Matt McCabe said in the group thread, when he was told that there was reporters in there getting pizza or whatever, heroes, whatever he sells there, Mediocre chicken parm, I've heard. Tell him the guy never went in the house. Right? What investigative source told them the information about the ring camera footage? I would love to know that. Interesting. Tell him the guy never went in the house. Don't text about it. We'll find out more tomorrow. The troopers are here. They're at the Asian house. McAlbert sources say, imagine what's in Proctor's phone. Do you think Proctor had any communications with any of these people? We know that he did because these same Haas plaintiffs have made a motion to have all that stuff impounded. All of their communications with anybody from the Norfolk DA's office, including law enforcement like Tully, Proctor, etc. Somebody said Channel 4, most likely it was Ken Berkowitz, who at the time was on medical leave. He was the chief of police of Canton, but he was on medical leave at the time, right? And yet he was all in and around the Canton PD, Sallyport, and inside the Canton PD station in the early morning hours, January 29th, 2022. Likewise, Reed utterly fails to reckon with the extensive allegations detailing her conspiracy to use defamation as a tool to intimidate and harass the plaintiffs. The AC alleges that Reed conspired with Kearney to publish defamatory material, in part for the purpose of intimidating and harassing the plaintiffs and their families. Reed makes no effort to justify this conduct, some of which was criminal, as petitioning activity. Indeed, conspiring to defame witnesses in order to intimidate them and the jury and jury tamper. Oh, now you're talking about jury tampering? Have they ever alleged jury tampering before? You know who did jury tamper? Michael Marcy, when he released his hostage video in defense of all of you in August of 2023, and told the public, the jury pool, that Michael Proctor did not plant taillight at 34 Fairview. In fact, Michael Proctor never went to 34 Fairview. Colin Albert was not in the house. And forensic cell phone data shows that John O'Keefe never went in the house, and 11 people say he never went in the house. And Karen Reed's defense is a false narrative. It needs to stop. Indeed, conspiring to defame witnesses in order to intimidate them and jury tamper is not petitioning activity because such criminal acts target private individuals and are not undertaken to reach governmental bodies. Reed herself embraced the impact of Kearney's criminal conduct when she messaged him, "Look at what you've done to their reputations and to my jury pool." Footnote 3, which reads, Massachusetts courts have already found that Kearney's conduct, which the AC alleges he jointly undertook with Reed, was likely criminal. For example, in denying Kearney's attempt to vacate a no-contact order in November of 2023, Judge Krupp explained that in pursuit of his performative journalism and personal brand, Kearney has berated witnesses in the Reed case, badgered them, and pressured them to change their testimony. Judge Krupp found that Kearney's actions demonstrate an intent to influence and pressure the witnesses to alter their testimony about the Reed case in violation of General Law 13A. I would have to look up that exact paper. Denying Kearney's attempt to vacate a no-contact order in November of 2023. Right, he hasn't been convicted of that. But it was used to deny a protective order against that who had against him? I don't remember. Yeah, so they would tell the truth. This is Gen X Gen. Your dad's favorite mom. Thanks for 5. Kieran Murphy is the one who does the dirty work for Jimbo Tuxbury because Jimbo will only talk to Damon Seligson. Thank you. For 5. Yellow Ledbetter is here and says, nothing better than sitting on the beach. Natasket? Nastasket? I don't know if that's supposed to say Nantucket, but if you're on the beach, you probably can't say because there's a lot of glare. With you in my ears on the beautiful day, waiting for the tall ships to pass by on the way to Boston. We should be on the yacht, though. Yacht today, Satan. Yacht today. Thanks for your 10. Overruled. Sit down. Says there's a man passed out in the snow, but you didn't see him in the snow. You could track a cat in. Key witnesses to what? Either you saw something or not. Make up your mind. Thank you. Overruled. Sit down. Oh, and P.S. You're all related. Except for Higgins. Higgins not related to anybody, but he did want to bang Karen Reed. So there's that. Violating the bro code of his friendship with John O'Keefe. Lindsay, thanks for 5, says, that's not accurate. A Duxbury cop who used to work with O'Keefe sent Aidan the original filing. Oh, thank you, Lindsay, for pointing that out. Kyle says, regarding Colin Albert, per a JAG relative, if the subpoenas existed before his reporting for duty or enlistment, the court or representative can simply contact the base commandants, the base commandant's JAG office after go through the JAG's office. Well, they need to know that. I mean, I feel like it would be easy to find out, but he said he left 4 voicemails and nobody returned his call because I guess they don't know who he is. Thanks, Kyle, for your 10. I love you. Jim's sister said, wouldn't it be great to have DNA proof from the carpet that was removed from 34 Fairview that Karen Reed now possesses? I don't know. I don't know how admissible that would be. I don't know what conditions it's been stored in. And so I don't know where in the house that carpet was. I just don't know what, if anything, it would yield. But I appreciate your 5. Alling Dog Design says, I wonder why Brian Albert et al. Aren't angry at the Proctor investigation. If anyone was aware of evidence and such, Brian Albert is one. He wouldn't invite police department to look around as long as they want. Why hide? Why lie? Yeah, good point. Good point. I agree, Alling Dog Design. Thank you for your 10. Oh, yeah. JP says they called on a holiday weekend. Oops. The Watcher says, as someone born in 1998, I wouldn't call that recent. Thanks for tuning in from across the pond. Emma, thanks for your 5 cents. It's amazing to me that these people are truly offended when their own defamatory words are used to describe them. Karen was found not guilty twice, right? And they keep calling her a murderer. They and their minions, maybe not they directly, but activity is preposterous. Reed's failure to demonstrate that the AC relies on petitioning activity alone is dispositive. But even the allegations she does address are either not alleged as defamation, footnote 4, or do not constitute petitioning activity. Footnote 4 says, he of the long-ass footnote. As set forth in section 2, plaintiffs do not contend that Reed's leaking of non-public information as to Kearney and misuse of court filings is itself defamation, but rather that such acts were in furtherance of their conspiracy and a course of conduct that included defamation, harassment, and intimidation. The court need not determine whether such conduct constitutes petitioning activity because the plaintiffs have not alleged that conduct to be defamation. And while Reed's statement to investigators concerning Colin and Brian Albert would not be actionable, the remainder of her conduct is. Oh, so they're admitting that Reed telling Yuri Buchanan when she's in cuffs in her pajamas in the barracks that Colin and Brian Albert beat up John and killed him, you're agreeing that that's not defamatory, okay? So therefore, what was put into the court filings about that is also not defamatory. Again, petitioning activity. So what else is it that you say you have here? All right, moving on. First, Reed's extra, I guess they're going to tell us. Reed's extrajudicial defamatory statement that McCabe committed perjury is not petitioning activity. Okay, but she did. She did. She lied to the FBI. She lied about lying to the FBI. She did not direct this statement to a governmental body, nor did she seek any relief in connection with her false accusation. She did not specify which testimony she purportedly believed to be false, nor presented any information to suggest that it was false. Rather, she made a bold blanket defamatory statement that could not obtain redress from the government. Second, Reed's extrajudicial post-verdict appearance on a podcast during which she defamed the plaintiffs cannot reasonably be understood as petitioning activity. Yeah, it can, because again, she was still being sued for wrongful death for a car accident that didn't happen. There's simply no objective, plausible nexus between her defamatory conduct and any redress being sought from the government. All right, I want you to keep this in mind as we go through this. Opposition. So far, I'm counting one statement they're claiming is defamatory against Jennifer McCabe. Jennifer McCabe perjured herself, right? That is specific against one of these plaintiffs. But it seems like everything else they're trying to say were just general statements that somebody inside the house murdered John O'Keefe. And as they just admitted to us in their papers, they cannot sue for her statement that Colin and Brian Albert beat up and killed John, right? So where are we going? Let's keep going. Reed's post hoc motive is irrelevant to the court's analysis. The court should not consider Reed's post hoc rationalization offered for the first time in response to this lawsuit at this stage of the proceedings. Reed's unsupported subjective rationale that she intended to keep her defense publicized is irrelevant. No, but it makes it petitioning activity. What is relevant is whether she engaged in petitioning activities alone. She claims that she intended to convince the O'Keefe family that it had sued the wrong party and should drop its suit. However, the AC alleges a course of conduct directed by Reed long before the O'Keefe family sued Reed for wrongful death in 2024. Right. Here's the thing. I said this when the O'Keefes filed their lawsuit. They filed it too early. Okay. They still had until January of 2025 to sue. It's a 3-day statute from the date of death. They had until January 28th, 2025 to sue, but instead they sued it in 2024. They sued Karen Reed, the Waterfall, and C.F. McCarthy's before the second trial ever happened. So both things overlapped, okay? Both things overlapped. Oops. And I said, why are they filing this now? They still have 6 months left. And they did. Moreover, the O'Keefe family is not a governmental body, and Reed fails to cite a single case where a defendant urging a private litigant to drop pending tort claims constitutes petitioning the government. That is, of course, because no such case exists. Reed also claims that she enlisted Kearney's help in part to publicize materials so that the public at large would understand that she had been framed. But these admissions demonstrate that she was not engaged in petitioning at all. The intended recipient of such information was not the government, but a segment of an online audience. The petition clause protects the right of individuals to appeal to courts and other forums established by the government for a resolution of legal disputes. Right. She's petitioning in the wrongful death case, which is a forum established by the government for resolution of legal disputes. Right. The Superior Court of the County of Plymouth. Hello. Sometimes we need Cardi B to just give me a break for a second. Rest my voice.
Hello.
Hello. Hello, I'm here.
Her head shake is everything. Her head swagger at the end is everything to me. Yes, the O'Keefe case is in front of a judicial body. It's in court. It is. It says right here, to courts and other forums established by the government for resolution of legal disputes. What exactly is this? It's exactly what this is. Right. Oy. The case law cited by Reed does not support her arguments. And then they're going to talk about some cases, which I will scroll through slowly while they discuss these cases that I have not read. So this is a cold read for me. And I'm sure somebody like Brother Counsel will read all the cases and explain them to you in his video, which I suggest that you watch when it comes out. So we will scroll through this, talking about other cases and whether or not they apply. Reed ignores the central holding of Cardno. Instead, she paints her non-petitioning, self-interested defamation campaign against private lay witnesses as similar to the activists in that case above. The SJC observed, this is what it said: the First Amendment had never been confirmed to petitions seeking to redress grievances that are either purely personal or purely public in nature. Well, I would argue to you that this this is not just personal to Karen Reed. This was personal to the worldwide public who were watching the conviction and framing and persecution twice of an innocent woman who did not kill a man with her car. And they say Reed made no comparable effort to influence governmental bodies. How else is she gonna influence them other than just speaking the truth? Is she gonna march from New Orleans to Washington, New Orleans to Washington, D.C., drafting press releases? Is she going to meet with federal officials like this case that you cited? Her conduct included covert communications with private citizens. She's allowed to do that. She's allowed to talk to reporters. Everyone is. Publication of personal identifying information. They were in public police reports. And the coordination of harassing voicemails, confrontations, and stalking. How did she coordinate that? That conduct bears no resemblance to the public advocacy at issue in Cardno, nor does Cardno support protection for a multi-year campaign that sought to intimidate witnesses, suppress testimony, and tamper with a jury pool. Right. The persecution of the marginalized defendant. Thank you, Anna. Debbie Jones says she could have put on a puppet show. She could have. Get the Muppets out there, do a little puppet show. We got the duck to show how ridiculous this is. If you don't know about the rubber duck lore, we also have, picked this up in London, Lady Diana, our classy rubber duck right here. Lady Diana. And then above me is the Handmaid's Tale duck, because the Canton PD did more of an investigation into the placement of little rubber ducks. Not this one. This one's a big rubber duck. Little tiny rubber ducks around Canton with stickers on the bottom that said Colin did it. Some of them said IYKYK, and some Monopoly money that was littered around town by a guy named Rich Schiffer, allegedly, that was stamped with justice for John O'Keefe, and Colin did it on the back. A 38-page police report was done for the witness intimidation charges brought against Richard Schiffer, because Chris Albert's feelings were hurt by the stickers on the bottom of those ducks, and so was Colin's. 38 pages. They went through this man's trash. They got subpoenas from makestickers.com because in his trash, they found the envelopes where he ordered the stickers from. They pulled flock camera footage from stoplights around town to show that he was in the area. They downloaded his Toyota TechStream data They did more of an investigation into Rich Shiver than they did into the murder of a Boston police officer, and you should be outraged. I don't know. If you're buffering, try refreshing your browser and come back in. YouTube has been having issues lately, as always. The puppet show would have been a good idea. Even if Reed's activity constituted petitioning activity alone, it was devoid of any reasonable factual support. I think a lot of people would disagree with you, but let's keep going. Go on with your bad selves. This court, because after this, guess what? Guess what we have after this? Affidavits of all 4 plaintiffs. Huh? What? That's right. This court need not proceed to stage 2 of the Bristol analysis. Reed's special motion to dismiss fails to meet the threshold burden that the plaintiff's claims are based solely on a legitimate petitioning activity. Nevertheless, her special motion to dismiss also fails stage 2. At that stage, plaintiffs must demonstrate that Reed's exercise of her right to petition was devoid of any reasonable factual support or any arguable basis in law and caused actual injury to the plaintiffs. Footnote 5. No, don't contact anyone, Kyle. Thank you, Kyle. Thank you, Kyle, for your deuce, but I'm not suggesting that anybody should contact anybody involved in this case, but I do love you very much, and I love your support, and I would not tell anybody to go reaching out to anybody, but thank you. Truth is his absolute defense to any defamation claim. Jen did lie, in my opinion. Thank you. Overruled. Sit down. She admitted that she lied to the FBI on the stand, right? To put it simply, the plaintiffs played no role in O'Keefe's death. They have never been identified by any law enforcement agency as suspects because there's never been any evidence of their involvement, right? And there's never been an investigation, a proper one. Ask Michael Easter. We went over his report, and you can see exactly why he was precluded from testifying, because he would have sunk their case. He would have sunk their battleship. See the declarations of Jennifer McCabe, Brian Albert, Colin Albert, and Brian Higgins attached here too. Oh, we will. They have never been arrested or charged in connection with O'Keefe's death. Not only did they willingly speak and share evidence with the police, but they also testified under oath to state and federal grand juries and during both of Reed's trials, right? They also destroyed evidence, deleted phone calls, made sus Google searches that were also deleted, destroyed their phones, and maybe, just maybe, coordinated with Michael Proctor and or other people in Michael Proctor's phone to frame Karen Reed. We haven't seen that part yet. But of course they were never charged. The SJC has held where criminal process does not follow allegations, no reasonable factual support of arguable beliefs. Okay, what? Where criminal process does not follow allegations, no reasonable factual support or arguable legal basis exists for the petitioning. Oh, really? So if you're never charged, she's not allowed to say that you did it? I don't know about that. But if Adam Deitch does get elected, and I hope he does, he will become the new district attorney for the county of Norfolk. And he has said in interviews that he fully intends to reopen the investigation into the murder of John O'Keefe. He did say that, right? We did watch that interview with Christina Rex. Seems like it. And he knows a lot more about it because he was with the U.S. Attorney's Office when the federal investigation into the investigation of the murder of John O'Keefe was done. And then in a mere footnote, which is, where's the footnote? Did I skip the footnote? Oh, the actual injury, footnote 5. Plaintiff's actual injury is pleaded in detail. Oh, your actual injury is just going to be in a footnote? First of all, the actual injury has to be specifically pled for each plaintiff with examples. Okay, so that's why they should not be represented all by the same attorney. I'm going to say it again. plaintiffs' actual injury as a whole, all the plaintiffs, 4 of them, prolonged harassment, intimidation, reputational harm, disruption to homes and businesses, and harm to family members. It's the amended complaint with all of these paragraphs in it. Emotional, reputational, and fiscal harms constitute legitimate categories of harms. You can't just say it generally, though. You have to say with specificity. But go on with your bad selves. I've only been a civil litigator for more than 30 years, but let's just trust me, bro. As set forth extensively in the plaintiff's opposition to defendant Aidan Kearney's special motion to dismiss, pursuant to the Massachusetts anti-SLAPP statute, which we don't have yet, or if it's been filed, we're going to do it in a different show. Reed's own admissions, data obtained from her vehicle and O'Keefe's cell phone, damage to Reed's vehicle, Reed's inculpatory conduct on the morning of January 29th of 2022, and the uncontroverted testimony of the plaintiffs all established that Reed was both responsible for O'Keefe's death and that she knew that she was. And then they're referring to their opposition to Aidan's motion. Reed's motion to dismiss pursuant to Rule 12b-6 must be denied because Reed does not challenge the amending complaint's new allegations concerning Reed's defamatory statements and conduct. Right. Colin joined the Army. What economic harm did he suffer? Kyle, thanks for your 5, says, I, Kyle Cowden, moved by Handmaid's Tale level stuff, opted to declare my information solely on my own volition. No other person suggested or asked me. Under his eye. Blessed be the fruit. Those statements accusing plaintiffs of murder, participating in O'Keefe's death, and framing Reed are independently sufficient to defeat Rule 12b-6 because Reed does not challenge them. She cannot show that plaintiffs have no legal basis for recovery. But again, with specificity. Who was she talking about? This is not just a blanket defamation claim. She said somebody in the house killed him. There was other people inside the house besides you 4. And you're claiming Colin wasn't in the house when John was. So again, this is not specific enough. And that's why it's bad for all of these plaintiffs to be lumped together. Murder. Murder. Thank you on top for your super sticker. I saw that fly by. Thank you on top. Reed's procedural argument pursuant to Rule 8A is misplaced. Under Rule 8A, a complaint must contain a short and plain statement of the claim showing that the pleader is entitled to relief, the purpose of which is to give fair notice of the claims of the parties. It's a 2005 case. Reed openly mischaracterizes the amended complaint. In reality, the amended complaint alleges and quotes numerous defamatory statements made by Reed, even though Rule 8A does not require such specificity. More than that, the AC identifies by date, substance, and manner of publication a lengthy series of statements attributable to Reed. For example, all right, let's hear all the examples, and then let's go to their affidavits. In an April 12, 2023 discovery motion, which Reed covertly disclosed to her co-defendant, Reed stated that Brian Albert and Colin Albert were responsible for O'Keefe's death and that McCabe was the mastermind who covered it up. Petitioning activity. In an interview with documentary filmmaker Terry Dunmore, Reed said that Jennifer McCabe got herself into a bad mess that night, helped clean it up, knew John was dying, helped expedite it. It was a first degree murderer, and that the other plaintiffs just finished him off. Let me ask you this, super sleuths in the chat. These statements here that Jennifer McCabe says that Karen Reed said to the documentarian, did they actually air that part of it? Was that part aired or was that part of the cutting room floor footage? I don't want to go back and watch that thing again to try and figure it out, but I'm just curious because they don't say whether it aired or not. May have been on the cutting room floor. So if that stuff was never made public, first of all, it's petitioning activity. Second of all, I'm not sure that that was in there. because they were probably afraid of getting sued themselves, this documentary company, and they probably didn't put it in there. During the same interview, Reed said of the witnesses, including plaintiffs, that they're murderers and they know it. On June 15th, 2024, Reed stated, Brian Higgins and Colin Albert may have had motives to kill O'Keefe, that Brian Albert could have used those motives as another reason to dislike O'Keefe, that Brian Albert did not care for John, that Colin Albert had issues with O'Keefe, and that the incident could have started when O'Keefe got mouthy with Colin and caught an uppercut. Again, these statements were made to Terry Moorer. Were they published? Were they part of the documentary? And if they weren't, the only person publishing these statements right now is yous, guys. This is why the Afro Man effect is a thing. Because now you are drawing attention to things. We have an Afro Man cupcake that Charissa made for us. Who thought that Afro Man would be the face of the First Amendment in 2026? Because now you are publishing these statements that did not air in the documentary because you think it helps you when no one's heard them, except you read them somewhere in a transcript. Because I'm pretty sure that if this part of the documentary aired, they would say that. Right? So again, you're just adding more attention to all of these things that you don't want anyone to think about you by putting them in a very public court filing. Okay. Next, on June 22nd, 2024, Reed stated that she knew Brian Higgins had a role in helping kill O'Keefe, helping him get in the snow and helping frame her. And she further stated that Brian Albert and Colin Albert would have enjoyed roughing John up. Again, was this made to the documentarian? Seems that way. In an ABC Impact Times Nightline episode, Reed's counsel, Jackson, stated that, again, I don't care what Jackson said. You can't attribute it to her. But bring it up again and keep repeating it so that everyone in the public can see it. For all the people who didn't see the Nightline episode, this is what Alan Jackson said. People in the house were actually responsible for O'Keefe's death and murdered him, that others in the house were covering up that murder, and that Jennifer McCabe knew O'Keefe was murdered inside the house and placed outside. On May 1, 2025, after McCabe testified, Reed told reporters that McCabe's testimony was another instance of perjury and that McCabe is lying. And that was on the courthouse steps, again, petitioning activity. In a January 12th, 2026 podcast interview, Reed stated that O'Keefe entered the house at 34 Fairview and much sooner than later met his demise. And she stated that someone in that house killed John O'Keefe, referring to the plaintiffs. Again, someone in the house. Tell him the guy never went in the house. That level of detail, dates, direct quotations, and identified means of publication spanning more than 50 numbered paragraphs provides Reed with more than fair notice of the claim against her as required by Rule 8A. Indeed, it provides a roadmap. Again, I don't think any of this stuff is not petitioning activity, but if you do, please let me know in the comments and in the chat, because I know you all have the independent ability to think for yourselves. Footnote 6, Reed's argument that count 1 is vague, likewise lacks merit, is highlighted herein. Count 1 is supported by extensive and detailed allegations describing Reed's defamatory statements and conduct. B, Reed's substantive argument related to the defamation count is without merit. Reed tells the court that nearly all of the statements attributed to her and the AC are not actionable defamation as a matter of law. She then challenges only 7 statements, some of which are not attributed to her at all, and many of which are included as background evidence for the many other claims brought against her. Nevertheless, dismissal would still be improper because, as Reed concedes by omission, there are other viable allegations supporting count 1. Given that Reed does not challenge many of the defamatory statements supporting count 1, the court need not consider the few that she does cherry pick. However, plaintiffs present the following analysis in response. Then they go on to talk about Reed's leak of non-public information to Kearney. And this is very repetitive, so it's all stuff that we talked about. Jen McCabe's failure to get a protective order, giving Aidan papers, talking about the FBI investigation. Their statements in connection with these leaks are not offered as specifications of defamation, but rather as evidence in support of their course of conduct and their conspiracy to commit various other torts. Okay. Reed cites no authority for her obviously incorrect position that where a multi-count action includes some non-defamatory allegations, the defamation count itself must be dismissed. Well, I don't know. Do you have any case law that even supports a cause of action for conspiracy to commit defamation? Is it even a thing in Massachusetts? And then they want to go on about the Karen Reed Turtle Boy official Facebook group, saying that they started, managed, and maintained complete editorial control over a Facebook group whose purpose was to publish defamatory material about the plaintiffs and to foment harassment against them. Maybe the purpose was to defend herself. Reed complains that we do not articulate any particular defamatory statements that she published to the Facebook group, but such specificity is not necessary where the general tenor of the defamatory conduct is alleged along with the precise language of other defamatory statements. Again, she's not responsible for what other people say on the internet. Jackson's extrajudicial defamation of the plaintiffs. The AC alleges that Jackson, acting as Reed's agent, defamed plaintiffs during a nationally televised broadcast when he accused plaintiffs of murdering O'Keefe and covering up that murder. Reed argues that count 1 must be dismissed to the extent that it is premised on Jackson's defamatory statement because the AC does not allege that Jackson himself is liable for defamation. In reality, the AC alleges that Jackson was repeatedly defaming the plaintiffs in service of Reed and her unlawful conduct. Okay, cool. Petitioning activity. Then they go on to discuss some cases. And what I really, really want to get to is their own affidavits. The amended complaint clearly alleges that Jackson defamed plaintiffs on Reed's behalf. Okay. Nothing more is required, particularly where the amended complaint and all reasonable inferences exhaustively details Jackson's role in defamatory course of conduct. How about he believes in his client's innocence? He believes that's what happened. He believes that that's what happened. And litigation privilege. Reads defamatory statements on Rotten Mango podcast. Okay. Someone in the house killed John O'Keefe. And then they say, by January 2026, Reed and Kearney had repeatedly and specifically identified the plaintiffs as the individuals in the house who were responsible for O'Keefe's death. Yeah, not all of Rotten Mango's viewers followed the Karen Reed case, so Karen says, doesn't refer to a single, it refers to a group, not a person. And they say, everyone should have known that it was about them. And so absolutely, it's defamatory. And then the amended complaint sufficiently alleged that Reed conspired with Kearney to commit unlawful acts. To state a claim for a civil conspiracy, a plaintiff must demonstrate that a combination of persons acted pursuant to an agreement to injure the plaintiff. Where's their agreement? There are 2 types of civil conspiracy: true conspiracy and concerted action conspiracy. Relevant for purposes of this action to state a claim for concerted action conspiracy, the plaintiff must allege plausibly an underlying tortious act in which two or more persons acted in concert and in furtherance of a common design or agreement. Right. But if those statements are protected as petitioning activity, the conspiracy claim also fails. And so they're going to go on. Defamation, harassment, abuse, intimidation. We were caused severe emotional distress. They formed an agreement, express or implied, to defame the plaintiffs and through intentional, reckless, and negligent conduct to inflict severe emotional distress on them, or to get the Commonwealth to drop the charges against Karen Read. They're saying that Read's use of intermediaries and encrypted communications to funnel information and false statements to Kearney, Kearney's admission that he received information and direction from Read and her legal team, Read's praise and encouragement of Kearney's publications, coordinated timing around court proceedings, shared financial and strategic interests, and joint efforts to conceal the relationship. Again, defendants are allowed to talk to reporters. That's what this was. As much as you want to make it about you, that's what this was. Read argues that count 10 must be dismissed because Read cannot be liable for unlawfully conspiring with Kearney if Kearney did not commit any substantive torts against the plaintiffs. And two, the amended complaint fails to allege that Read substantially assisted Kearney. They say that fails. First, her argument that her conspiracy liability is contingent on the court's resolution of Kearney's B-12-6 motion is an improper basis to adjudicate her motion. It would be entirely speculative to consider whether and to what extent the court's adjudication of Kearney's motion will impact Read's conspiracy liability. Second, Read is simply wrong that her liability for conspiracy turns on whether she rendered substantial assistance to Kearney. All that is required is that plaintiffs plead that Read and Kearney engaged in an underlying tortious act in which they acted in concert and in furtherance of a common design or agreement. Nevertheless, the amended complaint alleges that Read did far more than substantially assist Kearney. It alleges that she directed his conduct in furtherance of their conspiracy. I don't think that anybody tells Aidan Kearney what to do, but you can let me know if you disagree. Likewise, count 10 alleges a non-exhaustive set of actions that Read took in furtherance of the conspiracy that went far beyond substantial assistance to Kearney. Moving on, there's some case law that says if somebody provides substantial assistance in the commission of the tort, they can be held liable for it, et cetera, et cetera, et cetera, et cetera. Here, the amended complaint alleges that Read herself committed torts against the plaintiffs in furtherance of her conspiracy with Aidan Kearney. And while the amended complaint certainly alleges that she provided substantial assistance to Kearney, her liability is not contingent on that assistance, where she is alleged to have committed torts of her own. In short, while plaintiffs need not allege that Read substantially assisted Kearney, we specifically allege it anyway, and that she did far more than that. Okay. The amended complaint sufficiently alleges that Read aided and abetted Kearney's illegal conduct. Again, is aiding and abetting defamation a thing? I don't know. Guess we're going to let the court decide. All the things she did that they're alleging, providing him with confidential information, using intermediaries, etc. They're really grasping at some wet paper straws here. And they're saying that she didn't address everything we said, It's very repetitive, and it's repeating a lot of the same arguments that we've already read, so I don't think there's any reason to read them again, but I will slowly scroll through in case you want to screenshot it and read it for yourself. They say plaintiffs have sufficiently alleged with adequate detail that Reed aided and abetted Kearney in his defamation, intentional infliction of emotional distress, negligent infliction of emotional distress. They also say, Little Roman 5 says the amended complaint sufficiently alleges that Reed intentionally inflicted emotional distress on the plaintiffs. And she did. I swear she did. She did. They're saying it is a claim. It is a claim that Reed spent 3 years, among other things, directing a co-conspirator's harassment campaign, hiring an investigator to confront a witness using tactics associated with a convicted sex offender's intimidation operation. Really? The investigator used the same tactics as Harvey Weinstein. What are they even talking about? Did they Google the investigator and it came up that the investigator worked for Harvey Weinstein at one time? Like, what does that have to do with anything? Whose fault is it? Her fault. Her fault. Her fault, says Lyndon Martingale, knowing that that is a quote from the Handmaid's Tale that still chills me to this day. Did anybody watch The Testaments? It's so good. Chase Infinity, who plays June Osborne's daughter, whose name escapes me, Hannah, was nominated for an Emmy yesterday. We talked about that last night. Yeah, it feels like they keep repeating and repeating, overkill. Unlawfully disclosing plaintiff's personal identifying information for the specific purpose of enabling third parties to find and confront them. None of that is speech, and Ms. Reed's motion does not mention any of it. All over, and then just going to keep repeating and repeating and repeating. I'll just leave it here so you can screenshot it if you like. Conclusion: for the foregoing reasons, the plaintiffs asked this court to deny defendant Reed's motion to dismiss and grant any further relief as the court deems just and proper. XOXO. I don't have the signature page on here, but that may be because because this thing was like over 1,000 pages. I only saved the first 30 because, storage and stuff in my computer. Before we get to the affidavit signed by the plaintiffs individually, let's go to chat for a moment. Thank you for hanging out with me for almost 4 hours today to listen to my dramatic reading of Karen Reed's motion to dismiss the defamation case and its opposition, as well as all accompanying affidavits. JP says, I have an honest question. Was Karen called before the federal grand jury in their investigation? No. The defendants, no. Defendant was not called. She was not called. No, not that I'm aware of. It's a good question, but I don't think so. I really don't know. I don't know, but she can't be forced to testify. So she would not go testify in front of a federal grand jury because that testimony could be used against her in her criminal case. And so she wouldn't. And I don't think that she would even be called to because she's a criminal defendant in a pending case. Or interviewed by the feds before the Haas defendants. I don't know. I doubt it. Thank you, JP. Rob Sarah said, still shocked that Karen misled us and Turtle Boy about Higgins. Zeke said, did Reed's team really screw up and move against the wrong complaint? If so, what will be the fallout? No. She eventually filed a second opposition 5 days later to the amended complaint. But the plaintiff's attorney is saying we shouldn't accept it because it's late. But we didn't learn that until halfway through, or like a couple pages into their opposition. Maybe it was on the first page. I don't remember. Kyle said, lots of people tell Turtle Boy what to do. He cares not. Truth. Fish-tastic fish fits. Says Melanie, if one of the House defendants had to get their own lawyer, does that mean that they'd all have to drop Tuxbury and Maddie due to conflict? Yes. Because once a lawyer has represented all of them, if it is determined there's a conflict and one of them leaves and gets another lawyer, they can't represent any of them. An MTD is a motion to dismiss. Motion to dismiss, Suzanne. It's a motion to dismiss the defamation case. I just can't put the full thing in my title of the show because YouTube limits me to 100 characters in my title. And there's some things that I might add to it. Higgins was a no-show at today's deposition. Where did you get that from, Diane? I had other people were telling me that he did show up. So I don't know. I do not know. All right, let's look at the declarations of all of the Haas plaintiffs. Shall we? I don't want to spread misinformation, so I don't know how you know that Higgins was a no-show. So I need receipts on that. All right, here we go. And here they are. First up is the declaration of Jennifer McCabe in support of the opposition to motion to dismiss. So they have to swear to certain things to get over this motion to dismiss. And so here we go. This is Jennifer McCabe's declaration. Jennifer McCabe, on oath, hereby depose and state as follows. I'm a plaintiff in the above captioned action. I have personal knowledge of all things stated herein. On the evening of January 28th, 2022, I was with friends and family at a restaurant and bar located in Canton, Massachusetts called the Waterfall Bar and Grill. Toward the end of the night, John O'Keefe and his girlfriend, defendant Karen Reed, came to the waterfall and socialized with my friends and family. As the waterfall was closing, my brother-in-law, Brian Albert, invited all of us to his home at 34 Fairview Road in Canton. After Officer O'Keefe left the waterfall, he texted me asking for the Albert's address, and I called him to give him the address. I understand that Ms. Reed drove with Officer O'Keefe to 34 Fairview. I never saw either Ms. Reed or Officer O'Keefe enter the home at 34 Fairview that night. Early in the morning of January 29th, 2022, I received a phone call from Officer O'Keefe's niece, who then put Ms. Reed on the phone. Ms. Reed was hysterical and told me that she had left Officer O'Keefe at the waterfall following a fight that the two had and that he had never come home. Ms. Reed also told me that she had a cracked taillight on her vehicle. I told Ms. Reed that I saw her leaving the waterfall with Officer O'Keefe and subsequently saw the two outside of 34 Fairview in Ms. Reed's vehicle. I further told, so she's saying that Karen told her that she had a cracked taillight when she first called her. See what's happening here? Jennifer McCabe is trying to prevent them from arguing that she cracked her taillight when she hit John's car after she left the house to go to Jen McCabe's house. See what I'm saying? I don't remember what her testimony was. If she ever told anyone anywhere ever that that's when Karen told her was in that first phone call, because she doesn't say what time this phone call is, but we know it was like at 4:55. I further told Ms. Reed that they did not come into the home at 34 Fairview. Trying to make it seem like Karen was still hammered and had no idea where she was or what she did the night before. And again, these are all Jen's words. Jen's words, because 3 is the magic number. Shortly after that phone call, Ms. Reed drove to my home unexpectedly. Along with Kerry Roberts, we drove back to Officer O'Keefe's home to drop off Ms. Reed's car and to make sure that Officer O'Keefe was not there. A lot of people have a lot of opinions about why they went back to 31 Meadows after she just left One Meadows and knew John wasn't there. Right. She's also acting like she didn't invite them over. Weird. Right. Fork to Spoon says, so you're worried about your boyfriend not coming home, but the only thing that comes to mind is the cracked taillight. Right. James Lynch says it was a drunk fight that went too far, period. I know. Everyone's out there, what do you think? There's no motive. There's no motive for Higgins or Brian Albert or Colin Albert to kill John O'Keefe. That drunk people don't need motive. Drunk people do stupid things. We all know that. It was likely an accident. It was the cover-up was in the crime. Nope. Right. No officer down, no Officer O'Keefe, but a man passed out in the snow. A guy, my dear friend of 10 years, there's a guy. He's unresponsive. Please come. While we were driving back to Officer O'Keefe's home, Ms. Reed stated, could I have hit him? Did I hit him? Ms. Reed also pointed her cracked taillight out to me and Carrie Roberts in the driveway of Officer O'Keefe's phone. You know what's so funny is that there's no ring camera footage of that. She testified that when they first got there, that's when Karen pointed out the cracked taillight, but there's no ring camera footage of that. There's ring camera footage of them all getting out of the cars and running into the house. Nobody looks at the taillight in the driveway. Tell me if I'm wrong. Ms. Reed immediately noticed Officer O'Keefe in the snow when she, Ms. Roberts, and I arrived at 34 Fairview that morning. After Officer O'Keefe had been found in the snow outside of 34 Fairview, I heard Ms. Reed state to a first responder, I hit him, I hit him, I hit him. Thank you, Suze, because I thought this too. In trial one, Jen said Karen showed her the cracked taillight in the McCabe's driveway. Trial two, Karen showed it to them at John's house. But there's no ring footage. Be in Trouble 31 is here. He says Karen actually bumped into the taillight on the ring camera. She did. But she didn't take off her shoes when she entered John's house. I know. And so she's guilty of murder. I know, Karma and Gaga. I know. How dare she? We have an emoji for that too. I spoke with police investigators on January 29th, 2022, and told them all of the foregoing. No. You never told anybody that you heard Karen Reed say, I hit him, I hit him, I hit him on January 29th of 2022. Right? Chat. First time Jennifer McCabe ever said that she heard Karen Reed say, I hit him, I hit him, I hit him, was when? In front of the grand jury or at trial? It was not in her initial statements at all. In fact, Alan Jackson gave her a transcript and said, tell me where you say that you heard Karen say, I hit him, I hit him, I hit him. Go ahead, I'll wait. And she said, but it's 227 pages. You want me to look at that whole thing? And he was like, yeah. So that's not true, right? Is she going to say that she told Proctor that and he didn't write it down because he's a terrible investigator and now they're all anti-Proctor, even though her father wrote a letter, because we read it the other night, an email to everyone in the government saying Michael Proctor is amazing and you should not fire him. He did an amazing job. I also testified before a grand jury that was convened in Norfolk County Superior Court. In addition, I testified at the 2 Norfolk Superior Court murder trials brought against Ms. Reed. I told the truth in all of my statements and testimony. Oh, okay. You only lied to the FBI. I understand that Ms. Reed has alleged that I conducted a Google search on my cell phone of Haas Long to Dying Cold at 2:27 a.m. on January 29th of 2022. That is not accurate. I did not conduct any such search at that time. Rather, I conducted that Google search at approximately 6:24 a.m. on January 29th of 2022. Also, the reason why I conducted that Google search at approximately 6:24 a.m. on January 29th of 2022 was because Ms. Reed asked me to do so. That is something that Carrie Roberts lied about to the grand jury. Carrie Roberts told the grand jury that she heard Karen Reed say Google hypothermia. Hosslong to dying cold. And then she admitted that she really didn't hear her say that. She just knew that she did say that. On January 30th, 2022, I visited the O'Keefe family at their home in Canton with Kerry Roberts, her daughter, and my daughter. After visiting the O'Keefes, I left with Kerry Roberts to drop Ms. Roberts' daughter off at the home of Sergeant Michael Lank, whose daughter is friends with Miss Roberts' daughter. Does anybody else see a problem with that? Because one of her statements says we went to drop off Kerry Roberts' daughter. One of them says we went to pick her up. So which one is it? Are you lying then or were you lying now? Upon arriving in the driveway of Sergeant Lank's home, Sergeant Lank's wife, Trish Lank, came out of the house and sat in the back seat of Miss Roberts' car. This was the first time I recall meeting Trish Lank. Really? So let me get this straight. It's like you're still in nor'easter weather on January 30th of 2022. And you go over there to drop off Kerry Roberts' daughter, which is in and of itself looks a little suspicious because, Michael Lank was the friendly, the Ray Donovan of the Albert family, who's, has been cleaning up Albert family business for decades. He also bit a man. And rather than go into the house, you guys are sitting in the freezing cold car, having just a little chat. And that's the first time you recall meeting her. And the only reason that we know that she went to Lank's house that day is because of her location data. Because she never told anybody that before. Oh, please. At a certain point during the conversation in Ms. Roberts' car on January 30th, 2022, I entered Sergeant and Julie Lank's home to use the bathroom. Oh, she did go in the house. At no point on January 30th, 2022, did I interact with Sergeant Michael Lank. Don't text about it. We'll find out more tomorrow. When were those text messages sent? If they were sent on the 29th and she went into their house on the 30th, I have questions. Why did you delete the Google search? On the morning of April 9th, 2023, I was approached in the driveway of my home by two individuals who did not originally identify themselves. My initial impression was that they were salespeople attempting to sell me something. Yes, because FBI agents typically dress like salespeople. What did you think they were trying to sell you? Electrolux vacuums or Cutco knives? Candy? Girl Scout cookies? When they first asked me to identify myself, I told them that I was not the homeowner, but that I was Nicole Albert in the hopes that they would leave my property. When I identified myself as Nicole Albert, the two individuals still did not identify themselves and subsequently left my property. Why don't you just say, sorry, I'm not interested, no soliciting? Why would you make up a fake name? Tupperware. But they don't sell Tupperware door to door. I think you had to go to a Tupperware party to get the Tupperware. Shortly after the two individuals left my property, I received a phone call from those same individuals. During that phone call, for the first time, the two individuals identified themselves as agents with the FBI and asked to meet with me. So take note, this is April 9th, 2023. Aidan Kearney had not yet been on the case. He did not publish his first article until April 18th. And the FBI is already questioning Jim McCabe. In response, I immediately identified myself as Jennifer McCabe and invited them back to my home for a meeting. However, I requested that they wait 10 minutes before returning so that I had time to change my clothes and brush my teeth. Well, that was so nice of them to grant you that courtesy, because Karen Reed on body cam footage was just asking Michael Proctor if she could put on some underwear before they bring her down to the station in June of 2022. And he made some funny jokes on the body cam. Like, can you believe her? All she cares about is how she looks for the camera. 10 minutes later, the FBI agents came back to my home and spoke with me inside for approximately 30 minutes. Ooh, that's a pretty long interview. When the April 9th, 2023 meeting concluded, the FBI agents asked if I had contacted anyone prior to the FBI's arrival to inform anyone of the FBI's visit. At that time, I recalled having a telephone conversation with my husband, Matthew McCabe, and Kerry Roberts and informed the FBI agents of the same. Shortly after the FBI agents left my home, I recalled that I also had telephone conversations with Peggy O'Keefe and Brian Albert and my witness advocate at the Norfolk DA's office prior to the FBI's are out. Really? Really? So in the span of a 30-minute interview, it took 30 minutes for your memories to just vanish about the 5 people that you called. Or did you just think that it wouldn't look good if you told the FBI that you called your brother-in-law, Boston police officer Brian Albert, owner of the home at 34 Fairview, on whose lawn the body of a dead Boston police officer, John O'Keefe, was found? Why did you need to call Peggy O'Keefe, John O'Keefe's mother? And why did you call your witness advocate at the Norfolk DA's office? And did you really call your witness advocate? Or did you call Michael Marcy? Because maybe they're all at the same phone number. I don't know. Just a hunch. Red, white, and blue forever says innocent people don't call 5 people in 10 minutes because the FBI is there, period. Right. And if her memory is so bad after 30 minutes, how can we trust the I hit him 3 times? Great point, Kaylee. Because the first time Jennifer McCabe ever said that was far longer than 30 minutes after it happened, right? JP says, Karen says she called Lally. That could be. I think he was Sergeant Brian Albert at the time. Thank you, Anna. Jennifer C, thanks for your 5. Now that he's Officer O'Keefe, but when he was on the, now he's Officer O'Keefe, but when he was on the lawn, right, he was in me MPS out in the snow. Thanks for your 5. Lamasu says, why did they write letters about how great Proctor is when they all said Proctor got so much wrong in his reports, right? They threw him under the bus. They sure did. On June 8th of 2023, I testified before a federal grand jury regarding the events of January 28 and 29, 2022. During those proceedings, I was questioned by acting U.S. Attorney Joshua Levy and Assistant U.S. Attorney Adam Deitch. Oh, Adam Deitch questioned you? All the more reason for him to become the district attorney's, the new district attorney of Norfolk County. Wow, I don't think I knew that. I don't think that I knew that Adam Deitch questioned Jennifer McCabe in front of the federal grand jury. Did anybody know that? Is that new news? Because he sold his house outside of Norfolk County and moved to Quincy specifically to run to replace Michael Marcy because of what he learned during this investigation and how corrupt he says Norfolk County is. In fact, he's going to start an anti-corruption task force inside the DA's office in Norfolk County. Following my testimony, both Mr. Levy and Mr. Deitch walked me down a hallway into a room where my attorney was waiting. When we were in the hallway, Mr. Levy apologized to me for having to go through the federal grand jury process and informed me that I was a great witness. In quotes, oh my God, she's so trying to puff herself up. Are you kidding? Now you're making Josh Levy a witness to find out if this is true? You think Josh Levy's going to come in and testify on your behalf that you are a great witness? Wow. Mr. Levy then repeated his comments to my attorney when we arrived in the waiting room. I mean, wow. She's trying to further her narrative that she's just a witness doing her witnessly duties, willing to testify to all the things, and that she's a really great witness. Even the AUSA, Lyndon says, even the AUSAs think I'm awesome. Can you make this up? I mean, wow. Is that necessary to put in there? Unless what? A little puffery? You're looking for some puffery? Oh my God. Mr. Levy then repeated his comments to my attorney when we arrived in the waiting room. Oh yeah, he even told my attorney how good I was as a witness, that I'm great. I have never been the target of any FBI investigation. And if you were, they wouldn't tell you. Or how about we can just say maybe yet? Some people might agree. I've never been the target of any FBI investigation, nor have I ever been indicted, charged, or prosecuted for anything related to the death of Officer O'Keefe. Some people might say yet. Ms. Reed never once said in my presence, either to me or anyone else, that she saw or observed Officer O'Keefe enter the home at 34 Fairview on January 29th of 2022. And how lucky is everyone that Karen Reed herself did not enter 34 Fairview on that evening. How would she know if she's the target of any FBI investigation? But it is subscribed and sworn to under the penalties of perjury, 7th day of July, 2026. Wow. So they just had her. She literally just signed off on this 2 days ago. Today's the 9th. And it's not a physical signature. It's a typed signature. Hang on, because part 4 hasn't been released yet, says Donkey's Noggin. I'm a really, 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 really good witness. Adam Deitch, question B. Begs the question. Interesting that Adam Deitch wants to run for the Norfolk DA's office position. The Norfolk DA. Attached to yesterday's stream, I linked the full interview that he did with Christina Rex. If you haven't watched it, I suggest that you do. Do you think that Josh Levy apologized to Jennifer McCabe for having to go through the federal grand jury process? Do you think that? Remember that the feds are the ones who turned over 3,074 pages of material to the defense and the prosecution before Karen Reed's first trial. And Josh Levy said, listen, in good conscience, I can't allow Karen Reed's case to go to trial. Here, take everything we have. Take some of the stuff that we have, including Proctor's text messages, the group text messages of Jennifer McCabe, Brian Albert, Nicole Albert, and Matt McCabe. Tell him the guy never went in the house. Proctor's messages, the ARCA reports. But don't worry, he was really sorry that you had to show up. So he was so sorry that you had to show up in June of 2023 that by the fall of that year, they turned over all of your group text messages. You might want to rethink that. Wow. Yeah, also, she created a timeline. She forgot to tell us that. She created a timeline because innocent people create timelines, says Steve-O. And yes, she created the timeline. She and Carrie Roberts. And she says that Peggy O'Keefe was the one who told them to do it. Moving now to the declaration of Brian Albert in support of this motion. One moment. Okay, let's hear what Brian Albert has to say. See if you see any lies detected. Brian Albert on oath hereby depose and state as follows. I am the plaintiff. I have personal knowledge of all this stuff. On the evening of January 28th, 2022, I was with friends at a restaurant and bar located in Canton, Massachusetts, called the Waterfall Bar and Grill. Okay, that's true. Towards the end of the night, John O'Keefe and his girlfriend, defendant Karen Reed, came to the waterfall and socialized with my friends and me. Also true. As the waterfall was closing, I invited the individuals I was socializing with at the waterfall to my home at 34 Fairview Road in Canton. Well, it's interesting because I remember him testifying that he didn't know they were coming to his house, but he would have welcomed them if they did. Remember that? I do. I never saw Reed or O'Keefe enter my house at 34 Fairview Road that night, nor did I see either of them present in my home at 34 Fairview Road at any time that night, he says. Remember on his stand, he said, but I wish I did. Or something like that. But I wish I did. I spoke with police investigators on January 29th of 2022 and told them all of the foregoing. I don't remember if he told Proctor or whoever took his statement that day that he invited them. I don't remember, but I'm sure that you guys do. I spoke with police investigators on January 29th, told them all the foregoing. I also testified before a federal grand jury as well as a grand jury that was convened in Norfolk County Superior Court. In addition, I testified at the first two Norfolk Superior Court murder trials, the first of two murder trials brought against Reed. I told the truth in all of my statements and testimony. I did not speak with Brian Higgins after he left 34 Fairview prior to learning that O'Keefe was discovered unresponsive on the front lawn of 34 Fairview at around 6:30 a.m. on January 29th of 2022. So you're saying that the 222 butt dial and butt answer, you didn't speak to anybody? Because remember, I don't remember how long those calls were. But I think one of them was like over 10 seconds long. I don't recall, but you guys can tell me because I'm sure you remember. He's saying he didn't speak to Brian Higgins after he left 34 Fairview until 6:30 in the morning. 22 seconds. It was 22 seconds. Really? It was 2:22 and it was 22 seconds. There's a lot that you can say in 22 seconds. We've done it before. We've done the test. It'd be interesting if anything is in Proctor's phone. Because who remembers what time Michael Proctor was notified? And he was like, yeah, I'm not coming because it's not a homicide yet. John O'Keefe was not pronounced until after 7 a.m., like 7:09. Be interesting to see if there's anything in there. I have never been the target of any FBI investigation, nor have I ever been indicted, charged, or prosecuted for anything related to the death of O'Keefe. Short and sweet. Keep it short and sweet. Subscribed and sworn to under the penalties of perjury the 7th day of July, just 2 days ago. Brian Albert. Next up is the declaration of Brian Higgins in support of the opposition of the motion to dismiss. Under oath, he says he's got personal knowledge of everything. On the evening of January 28th, 2022, I was with friends at a restaurant and bar located in Canton, Massachusetts called The Waterfall. Toward the end of the night, John O'Keefe and his girlfriend, defendant Karen Reed, came to The Waterfall and socialized with my friends and me. Well, the actuality of it is Karen Reed wouldn't talk to you. She ghosted you. You texted her while she was there. Well, she wouldn't even look at you or say hello to you. You felt ghosted and maybe, just maybe, you got mad about it. I don't know. As the waterfall was closing, Brian Albert invited me and others at the waterfall to his home at 34 Fairview Road in Canton. I never saw either Reed or O'Keefe enter the home at 34 Fairview Road that night, nor did I see either of them present in the home at 34 Fairview Road at any time that night. Tell him the guy never went in the house. You see that you're sticking to the script. I spoke with police investigators on February 3rd of 2022. Right, he did. He did, and told them all of the foregoing. Yeah, you told them a lot more than that, though, didn't you? Because when police investigators met with you at your lawyer's house on February 2nd of 2022, you, before that, had gone to the FBI where your buddy Matt Kelch works, and he taught you how to use the kiosk, which is also improper, to cherry pick all the text messages that you say you had between you and John O'Keefe and you and Karen Reed, and brought them with you in a nice printed up package. Did you have a rubber band around it or a binder clip? Was it in a manila envelope? I'm curious. You told them a lot more than that. And they never even considered you a suspect, even though you and Karen Reed were having this 2-week long textationship and had met like in person once or twice. Maybe there was a little kiss. And you were asking her about where your relationship was going, what her end game was. You really think I'm what? A lot more than that. And what's really interesting is that his lawyer's house, where they conducted this interview, that wasn't recorded or signed or anything memorialized in any way other than whoever wrote it, however long later. Your lawyer at the time was also married to a sitting judge. So the police came to interview you in the house of a sitting judge, where you provided all your own evidence. Nobody ever asked you for your phone. Nobody ever wanted to extract your phone. Don't worry, buddy. I got you. Nobody ever considered you a suspect, even though you were having a thing and trying to have a thing with the dead police officer's girlfriend, who is now this was after she was arraigned for his vehicular manslaughter, February 3rd, after she was already arraigned, after Julie Albert told Courtney Proctor, tell your brother I want to get him a thank you gift when this is all over. And Proctor said, tell her to get my wife a gift instead. I also testified before a federal grand jury, as well as a grand jury that was convened in Norfolk Superior Court. Right. Didn't you say also? In addition, I testified at the first of 2 Norfolk Superior Court murder trials brought against Rita. I told the truth in all my statements and testimony. Right. Didn't you testify on the stand that you saw a tall, dark-haired male stranger walk in the house that you didn't recognize? Didn't you testify to that? So that is the truth. Okay, so that's the truth. Good thing. Got it. After I left 34 Fairview on January 29th, 2022, I went to the Canton Police Department to perform administrative work, including, among other things, moving certain police vehicles in anticipation of a snowstorm. You were hammered. You said you left 34 Fairview because they didn't have any JMO and you don't like beer. After being at a police officer's funeral in New York City for 2 days, driving home with Brian Albert, and maybe drinking a whole hell of a lot. Does anybody think that Brian Higgins actually went home that night, or do you think that he slept over at the Canton PD? Because he had an office there. I think he stayed there. I don't think he ever went home, but he claims he went home and he was sleeping on his couch after more food and more booze. And that's when the butt dial and butt answer happened at 2:22. I did not speak with Brian Albert after leaving 34 Fairview prior to learning that O'Keefe was discovered unresponsive on the front lawn of 34 Fairview at around 6:30 a.m. on January 29th, 2022. I have never been the target of any FBI investigation, nor have I ever been indicted, charged, or prosecuted for anything related to the death of O'Keefe. Here's the thing. There's no statute of limitations on murder. Subscribed and sworn to under the penalties of perjury this 7th day of July, 2026. XOXO, Brian Higgins. Next up. Oh, this is supposed to be Colin Albert's affidavit, but look how it was scanned into the computer. You can only see like the first 4 words of every sentence. Oh, well, I guess we're going to have to wait for a good copy of that. Interesting that they were able to reach him 2 days ago while he's in boot camp to sign an affidavit, but they couldn't reach him to get him to give dates to show up for his deposition. I have questions. How did they get a hold of Brian Albert? Who did they call? Colin Albert. He's in boot camp. He can't possibly come until, the fall. It has to be Colin Alberts because that's the only one that's missing. He's the 4th. And all I can see here is Uncle's house. On the evening and Uncle's house, 34 Fairview, Albert Jr.'s birthday. I arrived at 34, and then it says at around 11, And then it says cousin Allie McCabe, Fairview. I realize these are only partial sentences. Don't drag Allie McCabe into it. And also, Allie McCabe is not your cousin. Okay. Can we clarify something? Allie McCabe is not his cousin. Why is he calling Allie McCabe his cousin? Allie McCabe is the daughter of Jennifer and Matt McCabe. Okay. Colin is the son of Chris Albert and Julie Albert. They are not cousins. Okay. Why are they misleading the court? I don't know. It's probably the affidavit that was used before in the O'Keefe case. Maybe. Tammy Tebow says, Brian, oh, Tammy, did you get your merch yet? It's on the way. Brian Albert was she won some merch one day. Brian Albert was a fellow officer and first responder and never left the house yelling what happened. Brian Higgins was a medic in the service. Why didn't they try and save him? Ugh, no, a simple call to 911 and we could be in a totally, totally different place. Tell me, what say you? Colin's affidavit is in my inbox. Thank you, Suze. And close some of these windows. The shrubbery is too thick. Do you have a shrubbery? Who's better than Glamour Suze? All of yous. It's a very collaborative chat we have here. It looks like somebody spilled somebody spilled a cup of coffee on this thing. But you know what? At least we'll be able to read it. Kinda. Here's Colin's affidavit. Here we go. Here it is. I mean, this is the way Sue's got it. I don't know. Did they eventually scan it in properly? It does look like there's a giant spill on it or something. But let's see if we can decode it. See when he signed it, first of all. Oh, his is longer. His is almost as long as Jen McCabe's. Oh, it's undated. Look at this. Look at this. It says June. So he didn't sign this in July. He signed this in June. But it doesn't say what day. And he physically signed it. Oh, that's interesting. None of these are notarized. Isn't that a requirement in Massachusetts? Should you have to have something notarized if you're not an attorney? I don't know. Here in New York, you got to be an attorney. I mean, here in New York, only attorneys can sign things that are not notarized. None of these have notary stamps on them. So I don't know if that matters or not. It's stamped by the court July 8th, but he says it was signed on June blank. Thank you, Susanna, for your Venmo. She says that I brighten her day. Oh, you're a sweet pea. Thank you so much. None of these are notarized. But again, I don't know if that's a requirement in Massachusetts. In most courts it is, but you know, whatevs. No big whoop. Here's Colin Albert's affidavit. I, Colin Albert, on oath, hereby depose and state as follows. I'm not a party to this lawsuit. Everything I say in this affidavit is based on my own personal knowledge. My own personal knowledge. Wait a second. He is a party to this lawsuit. He is a party to this lawsuit. It's got the wrong caption on it. This affidavit is in the O'Keefe versus CNC Waterfall and McCarthy. What we are reading is the defamation case. And so I don't know what this affidavit is for, but it's not for this case. See how the caption is wrong? This is the one they produced already in his lawsuit. Okay, but this is not his lawsuit. It says I'm not a party to his lawsuit, to this lawsuit. I don't know what the hell this is. This is from the last one. What last one? Has there been a motion to dismiss in the O'Keefe versus Reed case? The wrongful death lawsuit? There's been motions to dismiss in the federal case, and there's been a motion to dismiss in the defamation case. Okay, the same thing they already filed, but with what? With what? With what paperwork? With what motion? So this is not responsive to this motion. This must be for his motion to not appear for his deposition in the other case. He filed this affidavit. I don't think we've ever seen this. We have not seen this. We've not seen this. This is the one where he says he can't come to his deposition. That's what it's for. I don't think we saw those papers because I think it was like private information of Colin Albert. All right, if you say we have, then we don't need to read it again, but this is not. I mean, it's possible that we read it again. This was the affidavit in support of his not showing up for his deposition. Right. My lawyers told me. So this is not the one that's attached to the motion, Suze. I don't know. So I don't know. Because this was. So this is not responsive to this motion. This is from his other case. So, I mean, from the other case where he couldn't show up for his deposition and whatnot. But we did read it. It was the affidavit and then we got it. And so I don't know if this is the same one that they just submitted with the motion. I would say no. This was about his phone, right? So there needs to be another one with the other caption on it. Otherwise, he's going to be SOL. That's what I say. No, the one that I found in the docket is the one that was only half. Then somebody sent me this one, and I'm not sure if this was the one that was actually filed with the court for the motion, so I can't speak to it yet. I gotta do a little due diligence and find out, because it just can't substitute the one from the other case. In this case, as Mystic Rose Petal says, this is the one in the other case, right? I think you're on vacation. I don't know. I think this was I think it was a half a David, and then we got the whole David. Judge G dropped the papers. He is mad at the House. The Higgins, Albert, and McCabe's lawyer. All right, it's in my inbox. I'll look for it. Sheepstead says, so Higgins knew before he texted Karen that John was deceased. She didn't tell him. Right. She didn't text John is dead to him until later in the afternoon, right? And he never responded to that. Interesting. Thank you. Of course he knew. We know he was at the house for the family meeting. Sarah B. Creative, thank you for super sticker. You're amazing. And JP says, Higgins isn't an ATF agent. He has been the target of an FBI investigation. Higgins is an ATF agent. He has been the target of an FBI investigation. The FBI conducts federal security clearance investigations. Thanks, JP. P5. Gail for becoming a member. Inverted Sneaker Gail for being here for 14 months. Overruled Sit Down says, when was Morrissey's crybaby letters to the feds after the federal visit to John McCabe? Yeah, I think they started in like May, if I recall. I think they started it in May of 2023. He started like writing letters to everybody, like freaking out, as I recall. tomorrow. Hold on. There's a 2 p.m. hearing in this case for the motion to compel. No, it's actually an O'Keefe versus Reed motion to compel. I can't remember who they're compelling or why, but it is at 2 p.m. We will be covering it live if there's a camera in there. If there's not going to be a camera in there, I will watch the Zoom if the Zoom is on, and then I will go live to report on it. So make sure your notifications is set because you don't want to miss that. And I think there's going to be a camera in there because there's a lot of public interest in this case. Is it the motion to compel Proctor? Is it the motion to compel Colin? Is it the motion to compel everyone? I think it's the motion to compel all the Alberts and McCabe's to come and testify. Thank you, Anne-Marie Crochets, for becoming a member. Reminder to smash the like button, hit the subscribe button if you're not subscribed, because, you know, it helps the girl out and it doesn't cost you anything. It's free. Look at the top left. It's dated 7/8/26. Yeah. That could be when it was like in the computer and then they changed the index number on it. So they're just gonna, I don't know how this affidavit is going to help them in this case. So I'm not going to read it again until I can, you know, digest it a little bit more and also confirm. Amory says, I'm a notary in Kansas and everything must be notarized concerning that type of paperwork. Same in New York. The date not fully entered written in is a huge red flag. Yeah, well, we know this is for the other case. This is for the why I can't come to my deposition case. No, it's not stamped 8th of July. It's just handwritten. I'll show you. Handwritten at the top, 7/8/26. The index number is crossed off and a different one is in, but it's the old caption. Stated July 8th of 2026. I'm not even gonna go through this until I can figure out where it came from, whether it was submitted with the opposition to Karen Reed's or Turtle Boys. I will go over Turtle Boys on another show, as I already stated. Everyone's telling me the papers are out. I don't have any more voice left. We've been here for 4.5 hours. I need to be fresh. I need to be fresh as a daisy to go over those papers, which I will tomorrow morning before the 2 p.m. hearing. Okay, deal? Emily C. says he forgot to do his math homework, so he just handed in his science homework and hoped the teacher wouldn't notice. Telling me your thoughts on Karen Reed's anti-slap motion to dismiss and whether you think that any of the things that she did does not fall under petitioning activity. Collins reused his affidavit. This is document 35.9 in the defamation case and document 124.2. All right, so I will look this up in a bit, 35.9. And then we can go over it tomorrow when we go over Turtle Boy's papers. How's that? Okay, sound good? I think Karen Reed's got some really good arguments based on what we know about the judge. I don't know if he's going to buy them. I also want to do a little more investigation into what it is exactly that the judge has been asking the attorneys to provide to him and go over that separately. Because I don't like to talk off the cuff all the time. I like to digest things sometimes so that I can explain them to you properly. JP says, we can't talk to Colin because he fled to the army, and please accept the affidavit we used in another case, hence why we lined out the case number. Yeah, exactly. Carrie's a talker. Says I'm a tiny bit behind, but what is with the tricky language in Jen McCabe's affidavit regarding Lank, his wife, Trish? I then entered Sergeant and Julie Lank's house. Is that what she said? Oh, that's interesting. I didn't pick that up. See, nothing gets by you guys. Thanks for tuning in from Canada. Please hit the like button to push the video out. And Mr. Group Petals, thanks for becoming a new member. We love you all. I love each and every one of you so much. All right. Plan on being back here tomorrow at, I got to see how long Turtle Boy's papers are so I can allot the proper time. Just make sure you have your notifications set. Make sure you're subscribed so you're going to get the notification and all of the other things like that. I love you with all my heart. If I don't see you soon, I'm going to die, but I am going to see you tomorrow. I think I got all the super chats. But Jezebel says she might be Daybell level Delulu. Thank you. And Donkey's Noggin said, I wish stupidity was painful. Thoughts, questions, comments, concerns before we wrap it? Thank you for hanging in there for 4.5 hours so that we could read through almost every word of this anti-slap motion to dismiss by Jen McCabe. I mean, not by Jen McCabe, by Karen Reed in the defamation case brought by Jennifer McCabe, Brian Albert, Brian Higgins, and Colin Albert against Aidan Kearney and Karen Reed. We will handle Turtle Boy's papers tomorrow because they weren't filed first. If they were filed first, I would have covered them first. Okay. When I pulled these off the docket this morning, none of them were labeled. I had to click through like 20 different documents to find them because they were hidden. They were not labeled. And his were not in there. But now that they are, we can do it tomorrow. Okay. I love you so much. Stay cool, stay kind, stay classy. Don't believe everything you read on the internet. Thank you, moderators. I could never, ever, ever do this without you. And I will see you guys tomorrow. Peace out.